Madam, serial number 48. Serial number 48. Mark the disposal. ಹೌದು ಟ್ರೈಲ್ ಕೊಟ್ಟಲ್ಲಿ ಮತ್ತೆ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೋದು. ಎಸ್ ಮ್ಯಾಮ್.
Madam. Whether it is in pending branch or statement branch. It's a new file. It's a old matter. Old matter. Madam, 36 reach ಆಗುತ್ತಾ? 36 ಮಧ್ಯಾಹ್ನ ಆಗುತ್ತಾ? ಅಲ್ಲ ಸ್ಲೋ ಇದಾರ, ನಾ ಈ ಕೋರ್ಟಿಗೆ ನಾವು ಜಾಸ್ತಿ ಬಂದಿಲ್ಲ, ಅದಕ್ಕೆ ಸ್ಲೋ ಇದಾರ ಫಾಸ್ಟ್? ಸ್ಲೋ ಆಯ್ತಾ, ವಾಚ್ ಮಾಡ್ತೀನಿ ನಾನು, ಬಟ್ ನೋಡ್ತಾ ಇರ್ತೀನಿ. Application.
The ladyship's kind leave. One memo. The urgency is only this. The petitioner is in his late 80s, likely to pass away. If his evidence is not recorded, the evidence may never be recorded and the suit will get irreparably damaged. Therefore, I'm moving the memo.
Which year is the suit?
The suit is of the year 1996, but this honorable court has granted me a stay. I'm seeking for the matter to be disposed of. Notes, it's a very short matter.
Which year is the writ petition?
21.
Give it, because the matter, the board is full for the next couple of days.
No.
So many matters are included in that.
Lordships may have it any date next week,
We'll see, give the slip.
please.
Yes, call the list,
Great.
Your Lordship's kindly, serial number 25, it became infraction.
25.
Please wait. 24.
By the MC itself is disposed of.
Please.
Then counsel the petition submits that the MC itself is disposed of and the petition has become infectious, dismissed as infectious.
Serial number 48 as well, ma'am.
48 also.
It arises out of a criminal miscellaneous proceedings. It has been settled
It is submitted that the out of court
48, 48.
48, the criminal miscellaneous petition itself is settled out of the court and the become has been, and the this petition has become infectious. Yes, accordingly dismissed.
My lord,
Give the slips to the memos to the court officer, we will see. Huh?
Yes, we thought for an interim prayer, my lord.
We'll see. It's not possible for the court to hear all the matters that are pending from yours.
Serial number 24, my Lord.
Yes.
In this case,
I
appearing
get,
to the
get
petition.
that.
Respondent is also present. Want to amicably settle the matter, my Lord. The charges are going on. Then sir, 2 weeks accommodation.
2022.
24, my Lord, serial number.
No, I'm saying
Max-
2022 writ petition
2020.
will, maximum will grant you a week.
Much of,
Pose this matter next week
date,
on 4th of July
much,
at request of both the parties.
much.
Serial number 22.
My lord.
Due to the
Yes.
undercut
Serial number
counsel
49,
throat
my lord.
infection.
Huh?
Undercut counsel throat infection, so I could not able to hear the matter. Kindly 1 week time granted. 22.
22 on 2nd of July.
My lord, serial number 36.
Yes.
My lord, my 4 IS has been dismissed in the trial court, for which I have which I have filed here, GMFC. And the trial court is insisting me to argue the matter. So kindly it may be dated, my lord.
Where is it?
I have filed a memo, according to.
We will see. Where is it is not in the list.
It's not in the list.
We
I
will
have filed
see,
memo.
we'll see that, which year is that? No, the problem is there are about
It is
60 matters.
2024 matter.
Huh?
2024 matter.
That's what we'll list it basing on the other matters also. You please give the memo. Yes.
My court is insisting me to finish the matter. That is what I am telling. A date may be fixed. This
Now
is the
it can't
second
be
time I
fixed.
am going
Now
this
it can't
memo.
be fixed. You have given the memos, court will see, basing on the urgency, looking at the reason given, will give a date. Yes.
Serial number
My
36.
lord, serial number 17, my lord.
Just wait.
The
Yes,
counsel on record has undergone surgery.
36.
So 36, so 2 weeks time may be granted.
At the request of learned counsel for the petitioner, post this matter after 2 weeks, it is submitted that the counsel is unwell. Yes.
Serial number 31, my lord. Senior
31.
is not feeling- so,
Huh?
Senior is not feeling well. I need an urgent. 31,
31,
respond.
post on 22nd of July. Any adjournment that is sought will give a long date.
Serial number
Yes.
46, my lord. 46, my lord.
appear
The senior is not keeping well, my lord. My lord, it may be taken up on second. my
We
lord.
will see when she's objecting, we will see when the matter reaches.
My lord,
yes.
on second, the senior is not there in.
We will see when she's objecting, then that can't be considered. We'll see whether there is why she is opposing it.
Yes, my
Yes.
My lord, my maybe dated.
We will
because-
see, the date. We'll see and give the date. Yes. Yes, Mr. Counsel?
My lord, serial number 17, my lord. Counsel on record is unwell. Mr. Giridhar is not keeping well. So he's asked me to take a short accommodation.
Serial number 40, My lord.
Serial number 17 and 70, in
ಇಲ್ಲ,
17.1, it is submitted to the council. Is
49, my
was this
lord.
matter on 9th July.
Please,
Yes.
my lord. Thank you.
Yes.
Yes, sir.
I appear
Respondent.
Thank you, Lord. It's yesterday's matter last week.
Yes.
December was,
So what was the order passed by the court last?
some,
39 to the
Lord,
Anachar A.
everything right was given, my lord, as ordered by this honorable court, everything has been complied, your lordship. It was passed. on
Fails to
9th.
cooperate in implementing this
Yes.
order after summer vacation and the mark comes up.
Yes.
Will be part, the
As
boys will be
directed by
handed
your
over to the
lordship.
father at Madhu, so and so. Now what is happening?
Serial number 49, my lord, 1 week time.
What is happening?
Afterwards, my lord, the time given by this honorable court comes to an end, my lord, the child got admitted to the school now, my lord. Now school, child is going to school. my lord. That is the position as on today.
What is the order of the court?
Order of the court, my lord, to, without considering the objections, my lord, and without deciding the territorial jurisdiction, directed to hand over the custody of the child. One child is with him, with the father, and younger child is with the mother.
Let's see the order, where is
Yes.
the page number?
22, my lord. It starts from page 14, your lord. Page annexure A, page 13.
Yes. Yes, mister.
Yes, page 10.
Page number Anachar A.
I've seen. What are your submissions?
My lord, the petitioner number 1 not residing at petition number 2. The petition number residing at Bangalore, not care of the petition number 2 in the said reason. The honorable trial court rightly passing the order and observe the above matter. The detail passed the order, order passed by the trial court. The first petitioner residing at Bangalore, Rajesh Nagar, working at,
How can there be is it a final order?
no,
Interim
here in
order.
IA.
In an IA, how can the court say that custody be given?
No, my lord, the education, most important
Whatever it
is
is,
child welfare.
Admitted fact is that is the child is with the mother. It is your case that she is not with the boy is not with the mother. The boy is with the grandparents. Mother is staying at Bangalore.
Bangalore.
No, the case of the mother is the other way, saying that no, she's also still in that place. No, all those things have to be decided in the main petition. No, in an interlocutory petition.
My
no,
lord,
you worked out your
no, my lord, the petitioner number 1 not permitted to visiting the
No, that is
correspondent.
that is what will be done by this court. Not this custody can't be given at this stage.
No, my lord, the trial court rightly passing the order, observe the above matter, and they said the petitioner not filed any objection in this application before the trial court. The trial court rightly passing the order, observe the both parties, both documents and observe the arguments, clearly pass the order, my lord. No error passed by the trial court, my lord. The petitioner number 1 not residing at pit number 2. The petitioner number 2, education is not vesting. The petition number 2 is the custody of the petition number 1 or grandfathers. Even till today, education is filed the education of the children, petition number 2, my lord. 1 year, in the year 2022, at the time, at the education, the petition number 2, educated, studying in the Auxilium school before the Aulali. At the time of the education, the petitioner intentionally taking to petition number 2, my lord. Therefore, humble request this honorable court, the petition number 1 not interested to take care of the petition number 1, petition number 2. The humble request this honorable court kindly allow the said, dismiss the said petition filed by the writ petition, my lord.
Allow it, you wanted.
Dismiss the petition filed by the petitioner, my lord.
Please come. The present petition is filed. By
One
the
request,
marshal.
my,
He can't, you are here, why the party?
that request of very personal inconvenience, the petition number 2 character is very bad. Already
This won't
allegation
be
is
different,
made.
her character in an
And
IA in a writ
the
petition
file
filed before this
of
court.
future of the petition number 2.
Agreed with the
to my
orders
lord.
passed in JNWC number 37 of, in IA number 1, in JNWC number 37 of 2023, dated 13th September 2023. The mother is before this court. The husband has filed GNWC number 37 of 2023, seeking interim custody. As filed, GNWC number 37 of 2023. In that, I number 1 is filed, seeking interim custody of the child by directing the respondent number 1 to hand over the child to the custody of the father. It is stated that the wife is not able to provide best education, and she has left the husband and she has left the boy at a native place at Madhur in her parents' house, and she is working in Bangalore as a teacher in a private school, and she has failed to comply the order of the Child Welfare Committee, Dodbalapur. The committee had ordered that the father is entitled to visit the child, but the mother is not allowing to see the mother is not allowing to see the child. It is the case of the father that the other child, the elder one, is staying with him, and he is able to provide the best education to the elder child. To that, the wife had filed her objections, stating that she is appropriate person to retain the custody of the boy, as he is minor, aged 8 years. And further, the court has to adjudicate as to whether
Now,
appointment
my
of a guardian is necessary before entertaining the petition. And accordingly, sought to dismiss prayed the court to dismiss the petition. The court below, by the order impugned, had directed the mother to hand over the custody of the child to the father within 1 month from the date of order. While passing the said order, the court has observed that the child needs to have both the love and affection of both the parents, and she cannot be tossed around from one parent to the other, as this may have traumatic and psychomatic effects on the child. The sufficient visitation rights can be granted if they are in the same town. And the courts have to look at the welfare of the child. On perusal of the material on record, the court observes that it clearly goes to show that the respondent number 2 is in the custody of the boy is in the custody, not respondent number 2. The boy is in the custody of the mother. Another child is in the custody of the father. The father in his affidavit has stated that the wife is residing, the boy is residing with his maternal grandparents' house at Madhur, and the mother is residing at Bangalore by working in a private school as a teacher. The court has come to the conclusion that the mother is not taking care of the child, as she is not residing with the son at Madhur. And in these kind of cases, court must be vigilant and shall consider the welfare of the child, and his interest would be the paramount consideration. And accordingly, ordered the interim custody of the boy to the father. Aggrieved thereby, the mother is before this court. Then counsel, earlier, when this matter has come up before this court, by order dated
April 2024.
by order dated 30. by order dated 4/4/2024. Nineteen-4, 2024, not 4/4, 19/4, 2024. Has permitted the father to visit the child on Tuesday, Wednesday, Saturday, and Sunday from 2 p.m. to 6 p.m. and further directed the mother to cooperate with the same. And the said interim arrangement is made from 24/2024 to 26/5/2024 as it was vacation for the boy. Next para. Today when the matter came up, land counsel for the petitioner, mother submits that as per the order passed by this court, the father has exercised the visitation rights. Now the boy has started going to the school. And the order needs to started going to the school. It is submitted that pending consideration of the main petition for the guardianship, the court ought not to have granted the custody, interim custody to the father when the boy is 8 years and is very much attached to
My lord, the boy is aged about 10 years now.
aged 10 years and who is very much attached to the mother. Land counsel submits that at best the father can have the visitation rights, but a custody cannot at this stage cannot be given to the father. Next. Land counsel appearing for the respondent husband submits that the court below had rightly passed the order granting the custody to the father as the mother is not able to take care of the child and he has been kept with the grandparents at Madhu and she is working at Bangalore. The father is able to take care of the needs of the first child and he is doing well in his studies. And she is not able to provide best education facilities to the boy and leaving him to the grandparents. The welfare of the boy, being at Madhur with the grandparents is not in the welfare of the boy. And the court below, considering all these issues, has rightly granted the custody of the boy to the father. He also submits that the character of the mother is not good and it would not be good for the boy to stay with her. Having heard the counsels on either side, peruse the entire material on the court. The father has filed a petition seeking custody of the child. Admittedly, as on the day when the petition is filed, the custody is with the mother. The boy is in the custody of the mother. They have two kids. The elder one is with the father and the younger one is with the mother. No, during the pendency of the guardian, the GNWC, when an IA is filed seeking interim custody, the court straight away cannot pass an order directing the interim custody of the boy from the mother to the father. It is the case of the father that the boy is staying with the grandparents. It is a case of the mother is that she is traveling from Madhur to Bangalore, from Bangalore to Madhur, and she's working in Bangalore
As teacher, MSc
as a teacher. No, whatever the father says, and without a full-fledged inquiry, the statements that are made by the parties at this stage cannot be considered. This court had interacted with both the children had an interaction with both the children and the mother and father. It is so unfortunate that the elder child who is staying with the mother is completely reluctant to talk to the father, and the younger boy who is with the mother is reluctant to talk to the father. When that is the mindset of the boy at this stage, granting the custody of the boy interim in an IA, even before deciding the GNWC to the father is not at all in the interest of the minor who is just 10 years old. All these aspects, whether the father is entitled for the custody or not, shall be decided by the court in the pending GNWC. As for now, the father stays in Bangalore and the boy is at Madhur. At best, the father can have the visitation rights. Now, if he can go on a Saturday and Sunday, both the days it would be granted, or else on a Sunday. Okay, he can go.
Saturday, Sunday, both.
My
At
lord may,
at this stage.
my lord may say 1 month once, your lordship, or my child.
No, no,
will
my
be-
No, that is very
No, what has
unfair on the
happened now,
part
my lord?
of the,
No, I don't
that is
want to say
unfair.
anything, my lord. Let him have the right, my lord. I will not come in the way.
that is very unfair on the part of the mother.
No, mother is not like
No,
that, my lord.
you retain,
No.
you have the custody of the boy.
Right, I am not opposing your lordship. All that I am saying is it must be limited to the child, your lordship, because what has happened, your lordship, during the course of this visit, my lord. He used to make a phone call and to ask the boy to speak to all unconcerned persons.
No,
your
no, no,
lordship,
my
and
lord,
spoil him, my
absolutely.
lord.
Okay, if
One
he,
of the
if he
issue, my
says
lord.
so, one
Yes,
minute.
that is the one of
If he says so, what happens?
1 month once, my lord.
No, what happens? If you ask the boy to speak to the uncle,
Going-
what will happen?
Minor school going boy, my lord, that you let him visit and interact with the boy, my lord, there is no problem at all, your lordship.
Nothing, those
Every
kind of restrictions can't be there.
Every
Let
Sunday,
let the boy have
15
have
days.
all the attachment with other family of the father also.
It will be
There's nothing wrong.
15 days.
No, no,
once,
no, my
lord.
lord.
No,
Kindly permitted to weekly 2 days, my lord, and also permitted to school education purpose, my lord,
I'll take the responsibility of education.
education.
what did you write?
At this father can.
At best, the father can have the visitation rights. During the course of argument, learned counsel for the petitioner, learned counsel the respondent father submits that he is ready to bear the educational expenses of the younger child.
Education, care of the education. As the education, care of the education.
What does it mean?
Same thing.
What did you write?
And then counsel for the student father submits that he is ready to bear education expense.
Educational expenses of the younger child who is with the mother. Hence, considering the same, in the light of the above discussion and considering all these aspects, this court is passing the following order. 1. The writ petition is disposed of. The father can exercise the visitation rights on every Saturday and Sunday during pending disposal of the GNWC. On a Saturday between, when is the school for the boy? He has a whole day school.
Yes, whole day school, Saturday. my lord.
On a Saturday between 5 and 7. On a Sunday between 12 to 4 o'clock. 5
12 to
o'clock,
5 o'clock,
That's
12 to
home-
5.
Homework
on a-
and other things will be there, your lordship.
Huh?
5 o'clock.
Homework, child study, my lord, homework and other things will be there, limited to 2-3 hours, your lordship.
Between 12
That's
and
the
3.
reason, otherwise, my lord.
12 and 3.
12 to 5, my lord. Please.
The mother shall cooperate with the same. And if any lapses on the part of the mother in complying with these orders will be viewed seriously. Yes.
Okay.
Yes, next.
Yeah, Order under challenge, my lord, formally to be quashed, your lord. Order under challenge.
No,
formally
the order is set aside.
quashed.
The order of the family court and so is set aside. Order is set aside. Yes. Yes, what are your instructions? Take that. We are only concerned with now at this stage,
Yes, ma'am.
the school expenses. Now, school fees is 12,050
Yes,
for both the children.
for both.
Which school they study?
Shri Mahatma Vidyalaya.
Huh?
Shri Mahatma Vidyalaya.
Ahamatma Vidyalaya.
This is, this, whatever the calculation you have given is for what?
Per month.
How can school fees be on a monthly basis?
It actually throughout the year, two installments we have to pay.
That I want to know. What is that? How much is how much is the school fees for the year?
1,44,000 each. Huh?
75,000 two installments for each number.
1,50,000 for both child,
Hmm.
which has to be paid in 2 installments.
And I asked you to furnish the details of the account and all here.
Yes, yes,
So 1,50,000 per year for both the kids.
yes.
These are the account. No, you've given the details of your account.
Yes, my lords. For the past 10 years, not even a single rupee.
No, I think this is not the place where we will decide
Yes,
about
of course.
the pending maintenance.
Of course.
This
of
is an
course.
interim measure
Yes.
taken by the court. So this
Yes.
court is now at present concerned with this year.
Yes.
And that will be whatever if she has paid the first term, that that will be transferred to her account.
Yes.
And what has to be paid to the school, you will transfer it to the school.
Yes, my lords.
So give the
Transfer, no, my lord.
furnish the detail.
No, my lords. Let him transfer to the account. We
Hmm.
will take care of that expenditure.
Why?
Because if he pays to the school, there will be unnecessary confusion in the school authorities. Already he has created havoc in the school. Therefore, we have decided not to interfere in school activities. She has suffered a lot on account of his interference. Let him transfer the money to the account. We will take care of it.
No, what so happened earlier.
Yes, ma'am.
Now, why everyone, both of them wants to carry it forward?
No, no.
No, it is before the court.
Yes.
If something happens and he takes advantage of any of the court order and he behaves in a way which he is not supposed to behave, court will take care of it. So why for everything, why there is a response of this nature?
Not that, because we have given account to the school and children account is linked to this account. We have to make arrangements for sufficient funds in the account. It will be taken transfer by them.
Why it is not that you will transfer to the school account?
No, it is for standing
is-
instructions,
huh?
standing instructions to be given. And the children account is linked to her account. If sufficient funds are maintained in that account, they will take transfer on the due date. That is how things are working.
Oh, this is the account linked with the school account?
Yes, yes, yes.
We have a app in which all their daily homeworks, everything will be
Everything.
updated in that. Whatever payments also, it comes in that.
That is the reason.
Okay.
Know about the school, what is happening, about the progress, all those things, why the father shouldn't know?
So ma'am, see, for both the students, they'll give us the link only through one device, it can be accessed. So in that, everything, like say my daughter's daily homeworks will be updated in that. And if there are any RT, they'll write it in the diary, plus additional, if anything is there, it will be updated for our reference. And even when the school fees comes, when it is due, those reminders come in that. And whenever there are some activities in the school, even those will all be updated in that. So that is why I had mentioned the devices also. So for two of them, we have to have two separate devices for login also. So login credentials will be restricted to one access, only one. That's fair. And the fee receipts, like, I can share it to him, showing that this much is debited. And because even I've submitted also the receipts, whatever it is, so. That's fine.
So it is, now according to you, the school fees 1,50,000. And you will submit the bill or receipt for that in the next, on the next date of
So that
hearing.
is the tuition fees,
Huh?
tuition fees will be that. And one time, it was all the books, shoes and uniform, it is one time which I've already paid, that is separately. That is every year we'll.
When the court had made it so simple yesterday to your advocate that you should furnish it, why should you make it so complicated? Why should you again give it a monthly thing? I just specifically asked your advocate, I want to know what is the school fees of the kids this year? That's such a simple question.
That is what I have furnished also,
Where-
but I have divided into
No,
monthly.
Not required, not a monthly thing. I didn't ask. I asked only the school fees, nothing
ma'am.
else. Remaining things will
School
come
fee,
later.
The first column is school fee and expenses.
I said the yearly school fees, which we'll ask them to do it. We are not here fixing the monthly maintenance of the boy and the boys, or the boy and the girl.
Oh, that's fine, but what transferred on the other day was.
I think what transpired in the court that is there in on
Yes,
on the
ma'am.
docket.
Yes. It is only yesterday,
Yes,
he
yesterday.
came out with meeting the school expenses. Till date, he was
Not
not.
till date.
uh,
It was never that. I said specifically what is this year's school fees.
Yes,
That's only, when you've given so much of breakup, I would, court wanted to know only the school fees.
my lord's school fee, only if it is only school fee, it is 1,50,000. Only fee, tuition fee,
By
nothing
the
else.
time the learned counsel for the mother shall place the details of school fees of both the children to be paid per annum.
Yes.
So clear, nothing else.
It's 1,50,000.
Huh.
1,50,000.
Yes, when will you pay 1,50,000?
My lords, they haven't given any annexures whatsoever with this memo.
Now, we will take a statement of 1,50,000, the school fees. And by the next date of hearing, she has to place before the court the school receipt for that amount. If some statement that is made before the court, if it is a false statement, you know what will follow.
Yes.
So let's not go into
Indeed,
that
ma'am.
aspect. Yes.
My lords,
1,50,000 he has to transfer
My lord.
to the,
my lords, the calculation comes to about 1,44,000
into the
as
calculation.
per what they have.
The other issues we will not go at this point of time. It is
my lords,
1,50,000.
my lords, we are comfortable making a direct credit to the school. Because while there's absolutely no trust between the husband and wife here, owing to what my learned brother on the other side also states, the same applies to him as well. We don't know if the money is transferred to her, what would happen, whether it would duly reach the children or not.
Ma'am, as soon as I make.
My lords,
I think your client cannot, you can't make such a statement on behalf of your client who has not paid a single penny from the last 7 years.
indeed,
How
my
they are living, how the kids are living for the last 7 years without a single pie from your client. If she is not paying, who is paying?
my lords, today, when the limited point which is before this court is pertaining to the fees of this particular year, we are not denying that we will not pay, my lords.
You have,
We-
you have no trust. It might not reach the children. If I can understand, if you are the one who is.
It's a
taking
fair
care
ask,
of,
my lords. It's a fair ask, my lords, that we are willing to credit to the school. We never said that. We are not denying that we will not pay, my lords. There is no way that I'm stating.
I'll record your submission with regard to that.
Yes, my lords, we are not denying this,
Yes, one,
but we would only pay it to the school. My lords.
yes, yes.
And my lords, my only other humble request is that since as a father, he may have the access to the records of the children, he may have access to what is the well-being, what is happening in the school.
Yes.
And those details should be divulged to the father. As a father, he also owes a responsibility. Likewise, when he owes a responsibility to pay the fee, he also has a responsibility clandestine on him in terms of the upkeep and taking care of the children.
I made it very clear when your colleague was there yesterday. if everything wants to be on a technical issue, I'm just telling you, when everything wants to be on, have to be on a technical, this court also know the limitations and the technicalities much better than what is placed before.
I'm
the
so
court.
sorry, my lords. I'm not on technicalities at all.
I'm just telling, if you will transfer that amount to 1,50,000 to her, number one, to her account, the court will pass any order, number one. Number two, the other thing is, I will ask her for that 1,50,000, a receipt to be filed before the court from the school that will come. Once your client is ready for that 1,50,000 to be transferred to her account, then the visitation rights, overnight custody of the child this weekend, and the matter would come up again on Monday or Tuesday. So this is the one. If it is acceptable to you, we'll pass an order. Or else whatever the court wants to pass, will pass.
Are you okay depositing the money to her? She will provide the receipt to the court.
That is what transpired on the last occasion in the court, saying that he will pay the fees, he will have the overnight custody of the child.
Yeah, she's telling she'll pay in by year. So I will pay that.
Okay.
It's like 1,50,000.
Okay, my lords, what my client is stating is, this particular fees is paid twice a year. In 2 installments is what they contended. So if she has paid the first installment, he is willing to clear that off against whatever receipts she would have, that anyways would have already been debited from her account. And whenever the next date, whichever date next date falls, on or before that, he will make sure that the transfers are made to her account. Because he will also make the payment on that particular date. Because they themselves stated that the fees is paid by.
How would your client will take care of both the kids if this is a bargain he wants?
No, it's not
How
a
would he-
bargain, my
how
lords.
would
It's
he-
I'm
how
just
would
going
he-
on, I'm just going on with their statement.
How would he take care of both their needs if if it has to be taken care of by him? If he has to take care of them and has she been staying with him and he has to take care, and which, now how old are they?
Son is 11, daughter is 8, 9.
Son is 11 and the daughter is 8. So son is going, how long both of you are separated?
Since 2017.
2017. Now that is 7 years. So from the last 7 years, she is paying the fees and taking care of the children.
But prior to that, he was
Prior
taking
to that,
care.
he's taking, I'm calculating something on 2017 to 2024. From the last 7 years, she is paying the fees. Maybe it may vary 10% here and there. Every year she's paying it. So when the time has come, when the court says that not about all these years, particular year of 1,50,000 to be paid, he has so many reservations on that. One, I'll pay to her account. I'll pay to the school account. Second, when it comes, I'll pay half of it. Why not 1,50,000? He can't pay.
And that's indeed, my lords, we are here to course correct and fix the issue with whatever has happened in the past to see how things can be managed and made better. With, of course, my lord's intervention in this. My lords, there are 2 issues that come. The father's name is not placed appropriately even in the records.
That's what I'm saying. For all these things, the matter will come up again on Tuesday. On Tuesday, the matter will come up again. Or this is the first stage. At this stage will not go into any of the aspects.
Right.
One aspect, fees, other aspect, overnight custody, and how it happens, we'll see it on a Tuesday. And that transfer has to happen. Now, the overnight custody would be from on the Friday or Saturday, whichever will ask her, that day, the overnight custody will happen. Before that, this thing should happen. This transfer of money to her account should happen. And either of it, either he doesn't follow, she doesn't follow the court order, the consequences will follow.
Okay.
I think I'll pass over because court will take care of the other business. Pass over, let him think over and tell. Yes, next.
Petition as such has become infructuous, my lord. Because the impugned order, which is at page 19. It was for
Custody of the minor child for celebration of the birthday of his father is hereby dismissed.
But, Your Honor.
IA number, 1 minute.
Yes.
IA number 8 filed with the respondent seeking interim custody of his minor son for celebrating so and so.
At the
The
13th.
respondent is permitted to have an interim custody of his minor son from the evening of till the evening of as sought for celebrating his birthday and drop the child from the residence. What has happened? There was an order,
Yes,
modification of the.
there was a
order.
modification and visitation happened that day in the visitation room. So this as such has become infructuous because he's exercised his rights of visit.
Your Honors, on the previous occasion, I'm counsel for the respondent. On the previous occasion, this court had expressed that the visitation aspect also will be taken care of by this court. Till for the past 1.5 years, the father has not seen the child regularly. He's not had any visitation. If the court can kindly permit visitation for once a week, maybe 2 to 3 hours, even the petitioner.
May I make a mention
But-
regarding this two things, sir? IA number 7 and IA number 8 are pending before the trial court, which is with regard to visitation and maintenance. Now, the trial court has benefit of all the documents which have been.
What benefit is required?
Please, my lord, in so far as IA number 8, that is for the maintenance, in last 2 years, the respondent has paid 10,000 rupees in all. And the affidavit.
How
is-
much was ordered by the court?
It is not yet been
That it's been
considered. 7 and 8, IA number 7 is for visitation, page 40 of the petition I've produced.
When did you file your IA for the visitation?
It was filed on page 40, sir.
Which court is this?
27/1/2024.
The trial court, family court,
It's
sixth
the
additional,
Which court is this? Which family court?
sixth additional.
Additional principal judge.
Bangalore.
Yes.
Please, kindly see page 40. On 27/1/2024, the respondent files IA number 7 for visitation.
That is not decided
It's
from,
not decided, so let it go before the court, we'll cooperate and.
no,
let-
no, IA number
7,
filed on
27/1/2024,
27/1.
2024.
Uh,
And IA number 8 has been filed on 2/3/2024. That is for my application for maintenance.
No, we will ask the court, we'll let the court to decide this, both the pending IAs.
Yes.
And in the meantime, let him have access to the child.
Your
Only
Honors,
for that
one one submission, I've asked you.
Acceding to it, sir, please listen to me. What I
Yes,
have to
please,
say.
please, please. Go.
The first and the third.
I think both
Saturday-
of you can argue outside the court.
No,
Yes.
only submission is first and third Saturdays. I'm willing to give visitation.
First and
Third Saturdays in the visitation room.
Your Honors, one submission. The plaintiff and the respondent, they stay 1.5 kilometers away. The residences are 1.5 kilometers away. There's a park right next to the petitioner's house, Krishna Rao Park. There, the respondent has some pets and some dogs. They are very close to the minor child. Another statement is, Your Honors, admittedly, the petitioner has moved away from the matrimonial home on 22/3/2023. It's almost 1.5 years now. Since then, there's been no regular visitation. Of course, the IAs are pending. I go to the court. Of course, the lower courts are better placed to appreciate all the documents and record. In fact, there's even a proceedings before the Child Welfare Committee also, in which the petitioner themselves had agreed for visitation twice a week. They had also given it on record. It's there on record. Of course, it may be decided what the circumstances are different. However, the petitioner had earlier agreed for twice a week for 2 to 3 hours. My only submission is that now it's a growing age. There's no respondent wishes to see the child. Maybe once a week at least may be considered. And then, of course, video call, provisions for video calls also may be.
yes.
And-
I made it very clear to all the family courts, for which I'm an administrative judge, that there shall be whenever an application is filed for this visitation rights, ex parte order should not be passed, and the moment the other party enters appearance at any cost, visitation has to be once in a week, but it all depends upon where is the venue, how it exercises. It all depends upon the facts of each case. So pending consideration of IA number will direct the court below to dispose of IA number 7 and 8 till such time such orders are passed with the court below. Now, both of you, as you say, you just stay very near to each other, 1 kilometer whatsoever he's saying. So, no, you don't have to put all your effort to travel here and there to, so that he wants to come, he will see. Let him come to the park on a weekend and let him have it.
May I make one submission, my lord? The apprehension of the party. kindly see, this is a case where previously the child was taken, 8 months child was taken
He
away.
was taken away. Now you're before the
No,
court.
the apprehension is.
Then
even-
if you have the same apprehension, why do you come to the court? Don't come to the court.
No, my lord, let it be in the visitation room.
One
since-
Not
submission,
necessary.
one
Not
submission, Your
necessary.
Honor.
No, I leave the child in daycare. He comes and he
If
insists
he
on the
does
child being-
anything, if he does anything contrary to the orders of the court, you're not helpless. You can bring it to the notice of the court will take it. No, you can't have both. You come to the court, you want the orders of the court. When it is to the other side, say that this is my apprehension. No, when both of you are before the court, he should not do anything contrary to the orders of the court. If he does, court will take care of it.
I understand, my lord. That is why I'm saying Saturdays, because I'm also a working woman now.
Sunday then,
Saturdays, first and third Saturdays, my lord. That is
no,
why
let
I
it
said-
be all Saturdays or whatever your convenience. If it is a Saturday or a Sunday, please tell the court. Accordingly, court will fix it.
Your Honor.
Whatever is convenient to you.
May I seek instructions on this?
Yes, pass
Your
over.
Honors, one submission, Your Honors. This
Yes.
park which I am mentioning is right next to the police
Yes.
station. If they have any apprehensions, it's right there, right next door to the police station as well.
It will be on a Saturday or a Sunday.
Your
in the
Honors,
week.
the the respondent is free even on the weekdays. He may be permitted if the court permits, even on a
But
weekday.
not
it is-
extend it beyond a point. Now,
Yes.
on a weekend, on one day, whichever is convenient to her, the order will be passed.
Yes, sir.
Remaining things, the court will take care. Yes,
Yes,
next matter.
Much.
Pass over this matter.
I'm appearing for the petitioner, my lord. Still, we have not received the acknowledgement. So kindly post it after two.
What acknowledgement?
The court had ordered to
The
ordered
petitioner
for the
take out notice of the
trial
council
court order.
appearing for the respondent before the court below.
Yes,
You have to serve notice and file a memo before the court. What is acknowledgement?
Still, we have not received the acknowledgement.
Who will give you? Who will give you the acknowledgement? Postal department? Court has permitted you to serve on the council and file a memo to that effect.
We'll file it.
You have to file it. This is 2019. Is it in the list? That list matter? We'll post it on Wednesday. By that time, please do the needful.
Sure.
Finally, post is matter on Wednesday. By that time, if the memo is not filed to the effect that the notice is served on the council appearing for the respondent before the court below, the writ petition will be dismissed on that ground. Yes, next.
The last occasion, this honorable court directed me to serve the copy on the counsel appearing for the respondent in trial court. He refused to receive the copy. Through court, a notice may be issued to the respondent.
Registry is directed to issue notice
Okay.
to the respondents.
Pair for petitioner in this case. I'll kindly reach you notice on the counsel of respondent. By mistake, I taken steps against respondent. I may be permitted to serve the copy to the other side counsel. Kindly reach you.
Counsel for the petition is permitted to take out notice on the counsel appearing for the respondent before the court below.
Please.
You took,
I taken against the respondent.
petition is then council submits that the council seeks a week's time to comply with the order passed by this court on the last occasion. Post this matter finally on 8th of July. By that time, if the memo is not filed, that petition shall stand dismissed without further reference to the courts.
Obliged.
Yes.
I am for the petitioner, my lord. Initially, my lord, the petitioner filed application under section 13(1) ABC, my lord.
Notice is not ordered so far in a 2023 petition.
Subsequently, the respondent filed application under section 9, my lord.
No, I'm saying in this writ petition, notice is not ordered so far.
No, my lord.
Coming up for the first time.
Please, my lord. Then the petitioner is living with the help of.
What is the order impugned?
It is 6,000 rupees per month, my lord. He is unemployed, my lord. He is living at the expense of the father, my lord. Father and mother.
Take out notice in all these 2023 matters, no stay can't be granted. What this learn counsel for the petition is permitted take out same notice on the council appearing before the court below for the respondent. And shall file a memo to that effect. Post this matter on 9th of July.
Matter may be stayed, my lord. Much obliged.
Copy has been served on them.
Today I will file wakalat my respondent too. Yesterday my client,
You are filing wakalat,
yesterday, today my.
Hmm.
Pray for time.
so papers on him.
It has already been served
Served my-
before the,
Yesterday my
before
client
the low court.
Came to my.
Monday,
Okay.
you're ready now?
No,
Monday.
pray for time.
Now, what is your name?
On behalf of AG Sridhar, my senior counsel, AG Sridhar.
Learn counsel, Mr. A.G. Sridhar submits that he has instructions to file wakalat on behalf of the respondent. Oh, and the council has, for the petitioner has already served papers on him. Post this matter on 3rd of July.
Please.
It's a challenge in the impinged order, interim maintenance of order, passed by the learned principal judge.
What happened to the
Shivamogga.
mic? Nobody is audible. Mic, is it on or not? Yes.
Your Honor, this learned trial court has not taken the earning capacity of the respondent. He is earning
Oh,
only
who is the
17,000.
petitioner? Wife or husband?
It's a husband,
Husband.
husband. filed
And
with it.
what is the maintenance granted by the
It's
court?
12,000 per month.
Huh?
12,000,
12,000 per month is granted.
yes.
What is the income of the husband?
The 17,000
How much now he is ready to pay?
is ready to pay 5,000, Your Honor,
Huh?
5 to 6,000. 5 to 6,000, 6,000 he can pay.
How much is earning? 12,000.
12,000
17,000.
ordered by the court, trial.
17,000 is his earning.
He earning it.
Pay 8,000.
And this, and
Pay 8,000. When is the date of petition?
it is December 12, Your Honor, 2022,
Which month?
2023. December 12th December 2023,
Is the petition.
petition filed. Order is on 16/3/2024. And respondent is gainfully
No.
employed.
12 plus 7, 19 months.
It is not 19 months, 6 months, Your Honor. 2023
Oh,
December,
2023.
6
Hmm.
months.
That month also you have to calculate. December plus the 7
Yes.
months. Please come. Learn counsel for the petitioner husband submits that though the income of the husband is 17,000, court had directed the husband to pay an amount of rupees 12,000 as maintenance. The court below had failed to consider the material on record and granted this amount of 12,000, which is very difficult for the husband to pay. Considering the submission of the learned counsel to the petitioner, there should be stay of all further proceeding pursuant to the order passed in so and so, on the condition that the petitioner shall continue to pay in amount of rupees 7,000 by 5th of every succeeding month and arrears for 7 months at 49,000 within 4 weeks from the date of receipt of the copy of the order. Either 7,000 per month is not paid or 49,000 as per the order of this court. 49,000 within 4 months. The writ petition stands dismissed without further reference to the court. Next, petitioner is permitted to take out notice from the council appearing before the court below and shall file a memo to that effect. 4 weeks means today is 26. July, we post this matter on 29th of July. A memo shall be filed with regard to service of notice to the respondent by 22nd of July.
In this case, I appear for the petitioner, my lords, it's a husband's petition, sought for a mandamus. The cross-examination of the petitioner has been posted from 12/11/2021, And ever since then, the cross-examination of the petitioner is still pending, my lords, on one or the other count.
Let us see the, you have filed the MC.
Yes, my lords, it is my petition before the trial court. My lords.
Let's
In
see
page
the
number
last-
41, my lords. In page number 41, I completed my evidence on
It's an MC of
7/10/2021.
Which court is
Yes.
this?
It is a second additional family court, Bangalore, my lords. I completed my evidence on 7/10/2021, my lords. Subsequently, the matter stood posted for cross-examination of petitioner on 12/11/2021 at in page number 41, my lords.
Please come. The present petition is filed, your mandamus, directing the court below to dispose of the matter within 6 months. When the counsel for the petitioner submits that the MC or the petitioner had filed MC number 49751, 4975 of 2018, seeking divorce, and in the one, and it is submitted that, what is the date you are saying?
12/11/2021, my lords.
12/11/2021. Your cross-examination has started.
Yes, my lords. It was posted for cross-examination on 12/11/2021.
Cross-examination of PW1. From there on, several adjournments. The court has adjourned the matter on several occasions. He submits that MC of 2018 is still pending. This court has looked at the order sheet. And looking at the fact that this is MC of 2018. This court deems it appropriate to direct the court below to dispose of the MC as expeditiously as possible. This court is not proposing to issue notice to the respondent, as no adverse orders are passed and disposal of the case is in the interest of both the parties. Yes.
Much obliged.
I appear for the petitioners, my lord. This is a petition filed by the father, my lords. And this honorable court on the last occasion had directed me to serve the notice to the counsel for the respondent in the honorable trial court, which I have done so, my lords.
Take that. This court, as per the orders passed by this court, dated, it's already filed.
Yes, my lords. Apologies, I'm just filing it now, my lords.
It's already filed.
It has already been served to my learned friend. Oh, it's already, apologies. Apologies.
How do we know that it is served on them?
My lords, my learned friend has been appearing for all the matters, including the GNWC matter itself, my
Given
lords.
him by hand.
My
No,
lords,
no, the difficulty with WhatsApp
understand.
and all is, no, you see two ticks.
I
No,
understand.
whether it is seen, not seen, whether it
True.
is knowledge, we don't know.
I
You will
understand.
serve him on,
But the problem is, my lords, the counsel for the respondent stays in Mysore. It's a different part of the state itself, my lords.
the counterpart there will serve him.
My lords, the only problem is he travels down to the city of Bangalore on every hearing date, my lords.
Issue a notice to the respondent, that's the only remedy.
It could do so, my lords, but my humble submission is this. At least in the meantime, visitation might be granted, my lords.
Without the presence of the other party, as far as visitation is concerned, no ex parte order can be passed. Because unless
Understand, my
until the
lords,
court
but the problem is
understands-
the honorable trial court does not even take into consideration of the application filed in the year 2023. Till now, there's no order been passed, my lords, with respect to visitation.
Or if you want that, we can dispose of the matter.
Please, my
directing
lords.
the court. below.
Please, my lords, it could happen. In fact, if I may bring to my lord's attention to two other aspects as well with respect to this. On the 16th of April 2024, my lords, if my lords may kindly peruse, ink page number 62, my lords. This is the order sheet of the Honorable Trial Court, and the typed copy, my lords, is at ink page number 68, my lords, wherein I had filed an IA, my lords, interim application under section 12,
seeking the custody, interim custody of the child with respect to summer vacations only, April and May, my lords. And subsequently, the matter was posted on the 23rd of May. The counsel for the respondent filed their objections. But when I had sought for a passover to argue the matter, the Honorable Trial Court had adjourned the matter to the 30th of May itself, my lords, which became infructuous, my lords, because April and May is what I was seeking for with respect to the custody of the
No,
child.
what is, which is IA
Subsequently.
pending, which is IA pending now?
All the IAs, my lords, from IA number 6 to IA number 10.
What is IA
subsequent-
number 6?
IA number 6 is under section 12 of the Guardians Act with respect to interim custody of the child for the month of April and May. It becomes infructuous.
This
Yes,
IA
my lords,
6
it
is
becomes
infructuous.
infructuous.
Next, what is
Subsequently,
IA 7?
IA number 7 is under order 12 with respect to section 12, my lords, with respect to everyday school and the swimming and skating and other activities to be, the child should be picked up by the father itself, my lords.
Then IA number 8?
IA number 8, my lords, is with respect to, again, taking interim custody of the child from 22/6 to 24/6. This is where the problem is, my lords. The petitioner's father is a priest at a temple at Lepakshi, and he wanted to perform certain pujas and rituals for the welfare of the child.
During the, when the school reopens, how can you have an interim custody at that time?
No, my lords, this is subsequently, after that. After the school has been reopened, this is on a Saturday and Sunday, my lords.
No,
The
you said
problem
you have
is,
given the dates in
Yes,
IA
my lords.
number 18, from so and so to so and so.
just 2 days, my lords, Saturday and Sunday, 22 to 24, my lords.
Also,
Yes, my lords. The only problem is
IA number 7 infructuous. Now,
The-
what is IA number 8?
that is IA number 8, my lords.
Then
IA number 7 is with respect to taking the child every day to school and dropping him.
So now what is live is IA
Bye.
number 7 only.
I understand, my lords. I bow down to this honorable court. My only humble submission is this. The honorable trial court, despite knowing the fact that there exists some kind of an urgency with respect to the interlocutory applications, has repeatedly granted a longer dates, my lord. If I may bring to my lord's attention to ink page number 69 again, my lords. It says to file objections on the 22/7/2024. It again become infructuous, my lord. But contrary, the respondent has filed a MC petition for divorce against the petitioner, and those dates are granted at a day-by-day matter itself, my lords. That is my only problem that I'm facing before the honorable trial court. When I'm seeking my right to at least have a visitation of the child, the same has not been ordered by the honorable trial court. IA number 2 is still pending, my lords.
Station rates would have been more reasonable than picking up.
I understand, my lords. IA number 2 is still pending. The honorable trial court has not ordered with respect to IA number 2. That is my IA itself, my lords. Visitation rights. That has not even been ordered till date.
Tell the court what is IA number 2?
IA number 2, if I may bring to my lord's attention, is visitation rights with respect to the child on every weekend, my lords.
I will ask the court to decide IA number 2.
Please, my lords.
The
Along with IA number 7, 9, and 10.
7 and all not so urgent. IA number 2, let it decide. The present petition is filed. Taking file to pass the order dated 35/2024. And also sought an alternative relief, directing the court to hear and pass appropriate orders on interlocutory application number 7 and application number 7, 8, 9, 10. In the last occasion, this court has directed the petitioner to take out notice on the counsel appearing for the court below. Submitted that they could serve the notice only through WhatsApp. The notice through WhatsApp. It is a case of the counsel appearing for the husband that MC is filed by wife.
By the wife.
That wife had filed MC seeking divorce.
Please, ma'am.
And the husband has filed the petition and the GNWC petition. In that, he had filed several IAs. One of the IA is seeking interim custody of the boy during the summer vacation. When that matter came up for hearing, the court had adjourned it beyond vacation, and virtually that application has become infructuous. He submits that when his applications filed under, all these IAs filed under the GNWC, where long dates were given. And when it comes to the MC petition, the court is going ahead with the matter on a day-to-day basis. Then counsel submits that the father has every right to meet the child. And if he is not able to meet the child often, that the bonding, there would be a gap, and that would create unnecessary inconvenience to the the father as well as the boy. This court had perused the applications that are filed. That the application that is filed, the order that is assigned before this court. Now, that is with regard to the visitation rights during the custody during the summer vacation. Now, in the considered opinion of this court, no further orders needs to be passed in the said petition as that become infractions now. Then coming to several IAs he has filed. Out of that, IA number 2 is filed seeking interim custody of the seeking visitation rights. And the said application is filed when?
On the same day, my lords, of the petition itself, which is on 23/11/2023, my lords.
It's filed on 23/11/2023. Considering all this court deems it appropriate to direct the court below to consider IA number 2 and pass appropriate orders as expeditiously as possible. Next, this court has not proposed to issue notice to the respondent as the disposal of the matter is in the interest of both the parties.
My lords, may I make a humble submission? If the time frame may be issued, my lords, at least within a period of a month with respect to visitation rights to be taken care by the Honorable
This
Trial Court.
court can't do it because, once the court says expeditiously, that will be heard. Yes.
And one more humble submission, my lords. IA number 9 is also in pursuance to IA number 2 itself. Even that may be taken into
Go ahead,
consideration. Please,
Yes.
much obliged.
The feeling aggrieved by the order at Annexure E, my lord, the petitioner has prepared this appeal, this writ petition. But facts matrix of this case is, or the
Should not.
Annexure E is the impugned order, my lord.
What is it?
But wherein, my lord, the trial court has directed the petitioner to pay a maintenance of interim maintenance of rupees 4 lakhs to the respondent. Sorry, 4,000 to the respondent. I'm sorry, 4,000 to the
What is the
respondent.
income of the husband?
My lord, he is a coolie, my lord,
Coolie will also earn something.
earn something, but here facts matrix are different, my lord. Not the marriage between the petitioner and the respondent was taken place on 29/6/1978. But they had a son, my lord, on 1980, in the year 1981. Thereafter, my lord, by entering into a written agreement, my lord, both of them separated from each other under a written agreement dated 17/3/1987.
Which has no legal sanctity.
Please, my lord.
Which has no legal sanctity.
Please, my lord, I'll come to that, my lord. But then, my lord, since 17/3/1987, they are residing away from each other. I have produced that written agreement also. But she voluntarily left the company of the petitioner. My lord, section 125 class 4 is clear, my lord, if the wife, my lord, I have extracted that, my lord, in
That all these, your submissions will hear it when once the other side enters appearance. Now at this stage, the stay, if you want, it would be a conditional order. So something you should pay. What is that you are ready to pay? Pay 2,000.
my lord, instead of paying it, my lord, I'll deposit before this honorable court, my lord, subject to the outcome of this writ petition. Because here, my lord, I'm aged 63 years as of now. Son is
When is the application?
Son is residing with the,
When is the application filed?
my lord, application was filed in the, on 12/9/2022.
12/9?
2022.
How many months till now?
My lord, 12 plus
12
3.
plus
3.
7, 19 months, I think.
Please, my lord.
19 months.
Please, my lord. Look, continue to deposit, my lord, from the date of order.
It is 38,000. 38,000 arrears, sir. 2,000 continue to deposit. The land council for the petitioner husband submits the
my lord, judicial order may kindly be. Judicial,
I'm not, submission is something, please listen to that.
please.
When counsel for the petitioner husband submits that the court below, without considering the crucial aspects of the date of marriage and when, and from from how long they have been separated, and the fact that the wife had voluntarily left the husband, and also even the son who is gainfully employed.
Please.
Correct?
Allah, he's an agriculturist, my lord. He's residing with, son is also an agriculturist.
He's earning.
Earning
Son who she's residing with the. son
43 years, my lord, son is
Who
40.
is earning. The court, without considering any of the factors, has granted maintenance of an amount of rupees 4,000. It is submitted that the husband is agriculturist and aged
Allah,
about 60.
Coolie, my lord, not
Coolie and aged about
63 years too.
63 years.
65.
65 years, and it will be very difficult for him to pay the amount. Considering the submission of the land council, they shall be stay off all further proceedings pursuant to the order passed in so and so, on the condition that he shall continue to deposit an amount of rupees 2,000.
Before this honorable. Before this.
2,000.
Please, man, before this honorable.
Continue to deposit an amount of rupees 2,000 before this court. And arrears within 4 weeks from the date of receipt of the copy of this order, an amount of rupees 38,000. Either he fails to pay that 2,000 or fails to deposit the amount, the stay granted by this court stands vacated. Same notice to the respondent.
Please, 8 weeks time I can.
Huh?
Coolie, my lord, 8 weeks time for deposit, please.
8 weeks. Post this matter on today's 26. Same, post on 29th of July.
Much.
Memo shall be filed by 22nd. Memo for service of notice.
August
on the
26.
July,
And I'm granted 8 weeks time.
you granted 8 weeks then. Then it is August 27th.
Please.
Post on August 27th, and the memo shall be filed by August 12th.
Much.
Yes.
Yes, appear for petition in the first matter. I may be permitted to serve the copy he has appeared.
Yes.
In connected
And-
matter, I accept notice, madam.
Hmm.
And the date may be fixed, madam. As per
Put in the
the,
name of Mr. Harish N.R.
please,
for respondents in WP 15998 of 2024. The counsel of the petition has served the papers on the council. Post this matter on 9th.
public.
Yes, next.
Appearing for petition.
Yes.
Milord, petitioner is challenging the order on IA number 5 in the common order with respect to rejection of the petitioner's prayer for interim custody of the killed on Saturday.
Interim custody?
Of the killed on Saturday. They have sought interim custody on Saturday and Sunday. Saturday it was rejected and Sunday it was been granted. And another order is passed on IA number 6 regarding maintenance measure that I will not challenge it. IA number 5, I have sought for custody of interim custody on Saturday also. There is the limited aspect.
Then let them, let there be a petition is permitted to take out notice on the council appearing before the court below with the respondent shall file a memo to that effect. When can you take?
After 2 weeks.
Post this matter on 16th of July.
Shall I serve the copy to the respondent? Counsel for respondent. Yes, please.
Yes.
First petitioner is the
This is
wife.
the one you were mentioning yesterday.
Yes, ma'am.
Yes.
Yeah. The first petitioner is the wife and the second petitioner is the daughter of the respondent. When the respondent failed to maintain the petitioner,
How much is granted by the court below?
this honorable court granted, enhance the maintenance to 9,000 to the first petitioner and 5,000 to the second petitioner. Till today, he is not paying any amount. For that reason, I filed 128 petition. So in that petition, I am seeking the direction to the employer of the respondent to withhold the terminal benefits. the respondent is going to retire on 30th of this month. That initially, that the trial court with pass an order to withhold the terminal benefits. Later on, the respondent filed application. So based on that said application, the earlier order has been recalled by the trial court. As against the said order, I filed the present bill.
Let's see the order.
Yes, page 41, madam. Page 41.
Yes.
Merit, madam. The respondent has filed IA number 5 to recall the order of this court dated 7/3/2024 for attachment of his term retirement benefits in the interest of justice and equity. It is stated that the court has ordered for attachment of retirement benefits of the respondent dated 7/3/2024. There is no provision to attach the retirement benefits of the workman respondent. The Honorable Calcutta High Court has held that gratuity held not attachable. The petition is filed make wrongful gain. On these grounds, the respondent prays to recall the attachment order for attachment order for retirement benefits in the interest of justice. The petitioner's counsel has filed an objection to the above application and contended that the respondent is working at Jaichamarajendra Zoo as a junior assistant. The petitioner has also filed memo for attachment of retirement benefits and obtained order from the court directing the DCF and executive of the Chamarajendra Zoological Garden to hold the retirement benefits of the respondent. Void order dated 7/3/2024. The court cannot revoke the said order. In the case before the Honorable High Court of Madras, it has been held that maintenance allowance granted to the wife cannot be considered as a debt. She is not a creditor, and hence the exemption under Section 11 of the Pension Act 1871 is not applicable. On these grounds, the petitioner's counsel prays to dismiss the IA number 5. Reasons that the petitioners have filed this petition to recover arrears of maintenance from the respondent in terms of order passed by this court in criminal miscellaneous 321/2011 dated 18/12/2014. In the said case, this court directed the respondent to pay a sum of 5,000 to the first petitioner and 2,500 to the second petitioner towards their maintenance. However, the respondent impugned the said order before the Honorable High Court of Karnataka by filing RPFC 4/2050. Void order dated 25/6/2021, the Honorable High Court of Karnataka enhanced the maintenance from 5,000 to 9,000 to the first petitioner and from 2,500 to 5,000 to the petitioner number 2 respectively. As per observations of the Honorable High Court of Karnataka, in the above said RPFC number 4/2050.
Some other judgments on this.
Yes, madam. Subsequently, madam, the wife and children in whose favor, madam, the maintenance awarded by the court are not the creditors, or it can be the terminal benefits of the husband can be attached to recover the arrears of maintenance.
The law that is laid down in that judgment is not about the creditor or debtor. Only issue is for any purpose, there can, whether there can be an attachment of the salary of the employee by way of a court order.
Yes.
Whatever is the relationship between the parties is not what is discussed by the apex court in that.
Yes.
No, on that, there are some subsequent judgments.
Yes.
Please look at that.
Division bench of the Bombay High Court held that. So that has been followed by the Kerala High Court as well as the Madras High Court. So this is the judgment of the division bench of Kerala High Court. Para 30 onwards.
Was this Supreme Court judgment considered in that?
But it is not mentioned. They consider several these things, married,
Yes.
with regard to the Stroud's Judicial Dictionary of Words and Phrases.
No, why this creditor thing has come? Where from you find this creditor?
Because the under Section 13 of the Payment of Gratuity Act, where it says any court or decree or in the suit or these things.
Where is the provision?
In Section 13, upon which the.
But remember, there are several judgments on that.
Yes.
Interpreting that. How it is when it is with the employee, and once it reaches the.
Suppose Suppose if the petitioner and the respondent are in good terms.
No, what is payable to you?
As and today, the total amount due is around 19 lakhs.
19 lakhs.
19 lakhs.
What were you doing?
After this,
Till that amount is accumulated.
after the order passed by this honorable court, your lordship may kindly turn to direction issued by this honorable court in RPFC. Your lordship may kindly turn to page 74, where the installment is also given. Insofar as arrears of maintenance, revision petitioner shall pay the same in 3 equal installments. The first installment to be started on 15/7/2021. Even after the specific direction by this honorable court, the petitioner, the respondent has not paid even a single rupee. May I read section 13? No gratuity payable under this act, and no gratuity payable to an employee employed in any establishment, factory, mine, oil field, plantation, port, railway company, or shop exempted under section 5 shall be liable to attachment in execution of any decree or order of any civil court, revenue or criminal court. This is not with respect to debt or loans raised by the concerned parties.
Where do you get that creditor? In 13?
But in 13 there is no such things.
13 language employed is very simple. It says, no gratuity payable under this act and no gratuity payable to an employee employed in any establishment, factory, mine, oil field, plantation, port, railway company or shop exempted under section 5 shall be liable
In execution of any decree.
in execution of any
Any
decree
decree.
or order of any civil revenue or
Any
criminal
decree
code.
means it does not include the maintenance. Because the
Need not be
decree, any decree means
It is
any
an
money
order.
recovery suit in decree
Order.
passed in any money recovery.
Decree or order. There
Yes.
is not so many words are used in that. Decree, order
Order.
of any civil,
Yeah, yes.
revenue or criminal court.
Yes.
No, criminal court has passed an order under 125 CRPC. No, there can't be a question of creditor, debtor, things that are discussed in, as far as this provision is concerned, I'm saying. Now let's come to the judgment. How the court has interpreted it. So where is that discussion starts with regard to section 13 of the Gratuity Act?
They have in this the court consider in consonance with section 11 of the Pensions Act 1987. Section 11 of the Pension Act 1871 and section 61G of Code of Civil Procedure. These are the two provisions under which the division bench has considered this. The creditor means why the creditor is discussed here. Any suit decree passed by the civil court or a criminal court. So it is only with respect to a creditor. It is a loan transaction between the decree is with respect to recovery of the any loan amount. Then only the creditor would, the question of creditor would arise.
It's Rule 124 of the rules
Yes.
that was considered
Yes,
by the court.
it is same parameter, yeah, same with the section 13 and 11 of the Pensions Act.
But
For that reason,
unfortunately, section 11 or section 13 do not refer to a creditor.
the creditor means any decree anta ide. For that reason, the court.
No order, it says any decree, any order. It has not, no, we can't
Now the question-
employ words
Yes.
and we can't read something into a provision which is not there. It is very clear, provision is very clear.
If that
There
is
is no
so,
scope for interpretation in that.
when that being the case, so the maintenance ordered by the court, any court, either under civil proceedings or under the criminal
So
proceedings.
the purpose
That also
of,
comes within the
no, the purpose of exempting the pensionary benefits is altogether on a aspect that, a person's that money
Yes.
which from a long years and which will be useful for him after retirement, if he's deprived of that, what would be his? That is the whole purport behind section
But
13 of.
in addition to that, now, my lord, in order to safeguard, my lord, the dependents of the, my lord, the particular employee, my lord, this particular has to be, my lord, extended to safeguard the interest of the destitute wife and children. Suppose if the same rule is applies to the, my lord,
There is
wife
one-
and children,
No, if I correctly remember.
the very purpose of
No,
the,
no,
my lord,
there is one more thing. No, as long as that pensionary benefit is with the employee,
yes,
you can't attach it. The moment that amount comes to the account of the person, it can be attached.
can be attached because, my lord, in the absence of a specific order, my lord, I cannot get, as a wife, my lord, I cannot get the account details as immediately as soon as the terminal benefits, my lord, transfer to the account of respondent.
No, apart from
So-
this judgment, please lay your hands on some. We'll have it, if you want it tomorrow, day after tomorrow, day after.
In the meantime, reason is this, man. 30th he is going to retire. Otherwise, man,
Something, no.
the
we have
second
to-
petitioner,
That's, this court has to legally, satisfy itself before passing any order. If you want a passover also, I'll grant. But you please place in consonance with what is the judgment of the apex court. This creditor thing is nowhere the
the decree
forthcoming
means,
from a pension.
where the decree and the any order comes in the definition, for that is, my lord, creditor and all, it is discussed in the judgment.
Some other Supreme Court judgment or this court judgment,
Yes, my lord, they have this matter of Thursday, day after tomorrow,
day after tomorrow.
please.
Day after, today is Wednesday,
Yes.
after tomorrow is Friday,
Friday. Tomorrow, ma'am,
tomorrow,
please.
yes.
Yesterday, your lordship has heard this matter.
Where is the other side? Yes,
In this case, I make an application to confirm the videos contained in the CD. And I produce the,
CDs and all yesterday was saying.
yes, yes,
So
ma'am.
exactly the court wanted to know what is that exhibit,
I have marked the exhibits, the photographs contained in the CD, my lords, as exhibit 7 series.
no, where is the order?
Order which is in page number 27, my lords. Last paragraph, it is.
No, in this, please tell the court, exhibit P7A, the transaction, the incident that you're referring, and then exhibit P8, both are one and the same.
P8 is DVD, my lords.
Ah,
P7 is the CD,
Correct.
which
What
is
I'm
contained the
saying
video of the,
No,
the,
one is video,
Yes, ma'am.
other is photographs.
Alla-
What from yesterday I'm asking is this photograph and the video pertains to the same incident?
yes, my lords.
So photographs are
Already I
already
have
on
produced
record.
and marked it, my lord.
No, you want for the same photographs. you
So
want a
video which is contained in the CD has to be confronted to the respondent.
Can't confront photographs. Ultimately want to say somebody is with her.
Some obscene video, some obscene
Somebody is
videos
with her.
with the
Everything is
respondent
captured.
and some other person.
Everything
That has
is
to be
captured.
confronted because if, after some time he came, he is not the person who along with me. That is the contention taken by the respondent while arguing the matter, if they are not confronted it to the respondent.
No, have you confronted the photos to her?
Still I am not confronted. Only it is marked as
What you
exhibit.
can know, the same content is in the video, and the same content is in the photographs.
Yes, my lord.
That photographs is already marked as exhibits. If you want to confront it, either a CD or a photograph doesn't make any difference. You can as well, that's what the court said.
That's a said observation, it may be disposed.
Yes. Court has already said so at para number so and so. Please come.
My lord, page number 28 ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
The court deems fit, the video is also necessary, then trial court make an observation that if deems fit, then it is look into it, and it is an observation made by the.
Therefore, the petition can very well make use of the said exhibited photos. That's what observation is there. Please come.
My lord,
No, order is in your favor. No argument required. The agreed by the.
Said observation could be made in the order. my lord. Then I make use of that.
Agreed by the order passed by the court below and an application filed by the petitioner. You are the petitioner? Petitioner
I'm the
is
petitioner.
husband.
Yes, ma'am. I'm the petitioner husband.
Their MC is filed?
MC is filed by me also, ma'am. By me, husband.
The present petition, the present petition is filed, agreed with the orders passed in. And an application filed by the husband under section 151 of CPC to confront a video in the CD to the respondent wife. The said application came to be dismissed by the court, agreed thereby. The husband is before this court. Husband has filed MC number 37 or what is the MC number?
37/18.
37 of 18, seeking divorce. In that, on his behalf, he has marked Exhibit P7A.
7 series. Number of photos are marked.
Exhibit P7A, and the said CD contains the photos which are marked as, several photographs are marked as exhibits. Now, it is the case of the husband that the wife in her evidence has admitted that there is a video recorded by her or by her husband, and it is her personal video. The said video is a material evidence and it is to be proved. Hence, he is permitted to confront the video to the wife, or else that he will be put to loss and inconvenience. To that, her wife had filed objections stating that there is no mention of the CD in the main petition as to how and from whom the petitioner, the husband has got it. Further, the husband has tried to bring a new theory during the cross-examination of the respondent, though he has not demonstrated as to how the CD was obtained. Further, it is for the petitioner to clarify about the persons present during the videograph and the audio recording and the particulars thereof. It is her case that there is no explanation either in the evidence of PW1 or his sister with regard to the alleged CD. Hence, the respondent has lost the opportunity to cross-examine the husband on the CD. And if the application is allowed, the same would cause prejudice to the wife. That application came to be dismissed by the court that already whatever is the content of the video in the form of CDs and different photographs are already marked as exhibits. Exhibit P8 is a DVD and as rightly objected by the other side, the particulars of the contents of the said DVD are not brought out during the evidence of either PW1 or PW2. It is also seen that the DVD has been marked earlier, subject to objection. The arguments touching the admissibility of the DVD are yet to be heard. And confronting the same DVD during the cross-examination of the respondent is not permissible. The court has observed that the authority of the person who was videographed and contents of Exhibit P8 and the persons involved in the said videograph are not spelled out. And it is very much necessary to play any CD or DVD in the open court to come to a proper conclusion in the matter. And nothing can prevent the court from adopting such procedure, and accordingly, the same was dismissed. The IA filed under section 151 CPC is dismissed. Next para. Learned counsel appearing for the petitioner submits that the content in the DVD, that is Exhibit P8, is marked The Exhibit P8 is marked subject to objection, which is a DVD. Exhibit P7, that is the CD containing the photographs, is already marked. He submits that considering the stand taken by the respondent wife, it is necessary that the video has to be confronted to her to show that to establish that she was indulged in relationship with some other person. The court, without considering these aspects, had dismissed the petition, submits that is very much relevant for the stand he had taken in his petition seeking divorce. Next para. Land counsel appearing for the respondent wife submits that there is no whisper about the CD about the videograph, and now suddenly, if the same is raised at the time when during the cross-examination of the wife had lost an opportunity to cross-examine the husband, and he cannot be permitted to come up with such a theory now. Next, having heard the counsels on either side, there is the material on record. Next, it's a case of the husband that the wife is having extramarital relationship with several persons. In support of that, he has already placed a CD containing the photographs before the court, and the same were marked. Several photographs were marked. In respect of the very same photographs, there is a videograph according to as submitted by the land counsel for the petitioner. That exhibit P8 is marked subject to objection, and the same is pending consultation before the court below. So at this stage, and the court below had rightly held that before admitting the same into evidence, several aspects have to be considered by the court. And at an appropriate time, the same would be considered by the court. Even that apart, when according to him, the same photographs, the content already marked, and the video contains the same material or the same incident, the husband could have confronted can confront the said photographs to the wife, and the court below had rightly dismissed the petition. This court finds no reasons to interfere. Accordingly dismissed. Yes, next. That a court already said, that's there on record. Yes. That's what I said. 18.
My lords, I appear for the petition.
17, they sought for adjournment that the counsel is not well. Please. Mr. Giridhar is not well. Please. Yes.
My lords, seal number 18, I appear for the petitioner, my lords. The matter is settled, my lords. We are withdrawing the petition. It may be posted on Monday, my lords. I'll file a memo with respect to that.
Not necessary. The land comes for the petitioner submits that the matter is settled outside the court. The recording the same, the writ petition dismissed as infractious. Yes.
I'm appear for the respondent in this case, man.
What is that?
Respondent counsel submits that even a single rupee is not paid as an interim maintenance. So as per the court.
To show that you're paid.
Yes.
Take that.
Please give me a copy. With
What is the
reference-
order impugned? Let's see.
Madam, 4,000 rupees for each kid and 50% of the educational expenses.
That is questioned by the wife
Yes, ma'am.
seeking enhancement.
Yes, ma'am.
What is the income of the husband?
He is practicing advocate and
How much according to you is earning?
Actually, my senior is out of station, madam. I'm not much aware of that.
You want time?
Yes,
My lord, one small submission, my lord. Just reference to the memo which is placed in the execution petition. Since from 2019 to till date, they were not paid. So one amount has been deposited before the court in the MC trial
No,
court.
there is a stay from this court?
They are
No, no,
submitting
no,
unfair-
my lord.
Unfair submission, madam. Yesterday, he told that even not 1 rupee is paid. We are submitting that all the
The
documents.
memo of calculation is here, more than 19 lakhs due is there, my lord. 2 children is there. They didn't pay court
Have you
school
not,
fee.
no, when there is no stay from this court,
Yes.
you know, you have not filed any execution petition?
Yeah, I already filed and arrest warrant also issued against our respondent, my lord. It means a petitioner. So till date is not appear, he is practicing advocate, they intentionally avoid to pay the interim maintenance. Due is arrears
Madam, I
nearly
provided
19 lakhs above is
address
due is
sheet of
there.
execution.
We'll have it on Monday, finally. Pose this matter as part heard on Monday.
I will, my lord, 1 week time may be granted, I will update the certificate copies in the execution petition, the entire order.
If you want
I will
to
place
take
before
the
this court,
emergency
1 week time,
Matter on 9th July,
after.
9th July. Yes.
Much.
Petitioner. Madam, day before yesterday, we filed a memo along with affidavit. This one, Wakalat, we filed, my lord. Have it next week, my lord.
Is it 2019
Yes, madam.
writ petition?
No,
Why
no,
should we
Patel
adjust it?
Karigoda is suffering from paralysis, madam. A day before yesterday, we filed. It shows the name of the
Pose this
K.
matter
Narayan.
on Wednesday, print the name in place of Mr.
K. Hanumantrayappa.
Print the name of Mr. K. Hanumantrayappa for the petition and delete the name of Mr. Karegowda. Next. Yes,
K. Hanumantrayappa.
AC is there. AC is on. AC is on. Yeah. Yes. Which one you call now? Serial number? Where is the counsel? No representation on behalf of the petitioner. Pose this matter for dismissal on Tuesday.
No, sir, I'm not right. 23 minutes, serial number.
21.
I'm sorry,
Till number 22 urgent, 23.
I am sorry. Petitioner, my lord. My lord, before the trial court, respondent is the plaintiff.
Last time also it is called, no?
Yeah.
This matter. This is not the case. WP 6408, that's what you have given me.
Yes, madam, 6408, I am for the petitioner.
23. Yes, what is the order impugned?
That is order passed by the first appellate court for the annexure F my lord. Dated 6/3/2021.
Page
Very
number?
Page number 34 to 45. madam. Madam, the first appellate court was pleased to confirm the order passed by the trial court, confirming the injunction order passed by the first court, my lord.
No, the order that is impugned is at page 49.
31, my lord, MA.
34 to 35, annexure F.
34.
Yeah, 34 to 45 minutes.
What is impugned before this court? Where is that order?
That is annexure F, my lord. Passed by the first appellate court in MA 20/2016.
This is impugned now.
Yes, my lord.
You are the plaintiff in the suit.
And I am the defendant in the suit.
Initially, injunction was granted or
Injunction was granted in favor of respondent.
Uh,
Against that, I preferred MA.
uh.
MA also came to be dismissed by confirming the order of the.
Now let us see the order passed by the trial court.
Yes, madam. The facts are like this, madam. The parties are relatives, joint family properties. There was a partition in the family. Each, group got 23 guntas. And after demarcation of the land, they are enjoying their respective shares. Like that, even my lord, defendant is also enjoying her share by constructing a house in the property. What the plaintiff did was, by giving the wrong boundaries, he filed a suit and he obtained an injunction order. My lord, the property which the plaintiff is claiming in the suit is the property where I am residing by constructing a house. I have said in the written statement in detail, wherein I have constructed a house by borrowing loan, by getting the plan approved, everything. In the written statement, para 10, void annexure, B, my lord. B is the written statement, wherein I have said, the property which is shown to be the property of Sushilama is now actually in possession of the second defendant. In this property, the defendant has built a house, which has also been accessed in the Agravanalli village panchayat. The said property has been given number as 361. This property is comprised in survey number 341/1, P2. Before undertaking construction of house by second defendant, the second defendant has even got prepared a sketch by the surveyor. The second defendant has even mortgaged the said property to take financial assistance from the government. These are the documents which I have produced, my lord. I have produced the photograph before my lord saying that I am residing there with my family. I am tethering my cattle. I have stored my food grains, everything. Now, my lord, even the observation of the trial court in para 10 of the order, my lord. If you want to see para 10 of the order, it would clear the entire this thing. Para 10 in page number 28, my lord.
Yes.
The plaintiff has filed present suit against the defendant for the relief of permanent injunction. On perusal materials and record, it appears that this case involves serious question of law and facts, and which requires trial. Whether the plaintiff is in possession and enjoyment of the suit property, or on the date of the suit, or whether the defendant have interfered with the plaintiff's peaceful possession and enjoyment over the suit property. But there is a serious question of law as observed the trial court. That means, my lord, while granting an injunction order, court ought to have taken note of the fact whether the plaintiff has made out a prima facie case or not. That he has failed to prove. And even, my lord, when passing the order, court has taken note of my mortgage deed, my lord. I had produced the mortgage deed, photographs, everything. Mortgage deed is the deed where I have borrowed money from a government agency to clear the loan, which I borrowed for the purpose of construction of house, my lord. I produced the photograph, my lord. Now, what has happened is, my lord, during the pendency of this MA, my lord, the plaintiff approaches the court once again and seeks for police protection. Annexure G is the order passed by the trial court granting police protection, my lord. In the event, if this order is not set aside, my lord, definitely they will come and throw me out of the house. Now, my lord, trial is yet to begin. I will have to produce all my documents, and I have to prove my possession of the property, and I'll have to convince the honorable court to show that I have been residing there by constructing a house. I have borrowed loan, I have mortgaged the property, even point the suspects, the bona fides of the plaintiff. So my respected submission to my lord is allow the writ petition, set aside the order of the first appellate court. So also by setting aside the order of the trial court. And let the honorable trial court go ahead with the matter. And let us find out whether I am staying there or not, my lord. And the honorable trial court where has heard the my lord, based on the revenue entries, it has come to a conclusion, para 11 of the order, my lord. Para 11, while answering point number 2 and 3, it has said, only based on some artificial extracts, mutation registry extract, Akarband, Uttar Akarband, encounter certificate, in para 11 of the order, my lord. Only on these basis, court has come to a conclusion that he is in possession. My lord, these are the revenue entries which do not confer any issue with regard to possession of the parties. I'm a poor man, my lord. I'm staying with my small kids, with my wife. In the event the police are permitted to enter upon the property on the strength of the court order, I will be thrown to the street, my lord.
No, the suit schedule property is 23 guntas, Mr. Counsel.
Yes, ma'am. Yes, ma'am.
Total extent
No, no, total extent is 23 guntas. According to you, the defendant's mother has, according to the defendant, his mother has purchased an extent of 2 guntas.
No.
2 guntas.
No, mother of the defendant does not purchase the property. So, sold to someone.
Whoever it is.
Third
that is-
person.
That is with regard to 2 guntas.
Yes, my lord.
So according to them, 21 guntas is in possession of the plaintiff.
Yes, ma'am.
2 guntas he sold. Now, the case of the defendant is that with the 2 guntas plaintiff is interfering by virtue of the interim order.
No. I am not interfering the, his position, my lordship. The defense interferes in my peaceful position, my lordship. The suit of the plaintiff to protect his property from the defense, my lordship. So agricultural land, my lordship, is the agricultural land. A grown plantation, my lordship. He is not able to plucking coconuts. And my lordship, kindly see that I produced documents. So the property acquired by the.
How
acquired
is
by
it
the-
situated? Where is that property? Is there any map for that?
My
Any
lordship.
map is filed before the court?
No. No, my lordship. My lordship is not disputed, my lordship. He is not disputing the entire extent, my lordship. He is only disputing the,
Correct.
what he constructed a house, my lordship.
That's the
Kindly-
only issue now.
Yes, my lordship, yes, my lordship. My lordship,
Now,
kindly-
entire 23 guntas of land belongs to you.
no, 21 guntas only belong to me.
In that. you sold-
Earlier, yes, my lordship.
In that you have sold 2 guntas to the somebody. Now in that defendant is in possession of of that 2 guntas.
No, I don't, no.
No, it's not agreement.
No.
Whatever that, no, I'm sorry for interruption, my lord. Whatever that they have sold 2 guntas, in the northern side, it has been shown as the property of the defendants. I have produced a rough sketch, my lord, your lordship.
Now, what is your case now?
My lord, there is a wrong boundary mentioned by him. They are coming and disturbing my house property where I have been residing. Let them admit that there is a house. Let there be inspection, my lord. By any sitting advocate of the honorable court, let him go and inspect whether I am staying there or not. Simply on the strength of the order, so also the order of the.
That's the only
court.
issue in this to be decided.
Yes,
What
my
is
lord.
What is condition, my lordship? So is
No, my
proper,
lord.
as according to him, my lordship, the what house is constructed. So after 2 guntas
No,
is situated,
no,
my,
it
according
is-
to him, my
No,
lordship.
no, this is very simple.
Yes, my lord.
In the extent is 23 guntas.
Yes, my lord.
Sue schedule property now according to you, because 2 guntas you have already sold, 21 is a sue schedule property.
Yes, my lordship.
Now, according to him, having sold the 2 guntas of land to so and so,
Yes.
and by virtue of that sale, however, he is in possession of the property. Now, under the guise of this 21, you are trying to interfere with the 2.
No, my lordship.
Exactly, my lord.
Where is 21, where is 2?
My lordship, they attached earlier, my lordship, to entire single boundary, my lordship, 23 guntas. So I sold the property 2 guntas to someone, my lordship. He, according to my lordship.
So when you have sold that 2 acres of land,
20
was there any demarcation done that day?
It has not been done, my lord.
My lordship is contains
that is
only
the
boundary, my
issue,
lordship, boundary what I have sold the properties are mentioned in the sale deed, my lordship. So on the northern side of the property, so is property situated, Sushilamma. So mother of the
Yes,
plaintiff, defendant is the
It is
Sushilamma.
very simple issue.
Yes, my
There
lordship.
can't be a blanket injunction like this.
No, 23 guntas is
He is
not.
also not saying that that 21 guntas do not belong to you. He says, you are the owner of 21 guntas,
Yes,
he is
my lord.
owner of 2 guntas.
No, my lordship, is not the case, my lordship.
100%,
Only-
my lord.
No, even if it is not his case, even if it is no, whatever is dealt by the court, no, we'll say, as far as the 21 guntas is
Yes,
concerned,
please.
that interim injunction should prevail.
Please.
Then where is the 2 guntas of land?
No, someone is residing, my lord. So someone is in possession of the property who has purchased the
It
property.
is no,
Yes, my lord.
guntas is not your property.
No, my lord. No, my lord.
So where
21
is-
guntas only my
Where
property.
is 21 guntas? Where is 2 guntas?
My lord. Kindly see the schedule of the property. my lord. Page number 470, my lordship. It's in Kannada, my lordship. Can I read? I shall see, my lordship. So on east, my lordship. So totally 23 guntas. So 2 guntas already sold to the someone, my lord. So boundaries remain 21 guntas. On the eastern side, my lord, road, and land belongs to the Kempamma. On western, my lordship, lands belong to the Shettegoda, Javregoda, please, my lordship. So on north side, my lordship, so land belong to the Chikkegoda, son of Chikkegoda. And on southern side, my lordship, so remaining property of 2 gundas, my lord.
Now, more or less, it is a dispute with regard to the boundaries.
Yes, my
And
lord.
more, and he is not, he is also a owner of the property.
No, my, he's not one of the property
Owner,
gundas.
it's like his mother has, That's what the court has recorded.
No, what
I'm
is
looking
condition,
for
my
the-
lordship?
I'm-
My lordship, I
Look,
sold the
I'm
property.
also having 23 guntas, my lord. I am also having 23 guntas. Where
Is it-
exactly his property lies and where exactly my property comes is the issue to be tried by the court by framing proper issues, my lord. And obviously, and presently, I am residing in the property which he is claiming that it is his property and he wants an injunction order in that property where my house is situated.
Lordship, on sold property 2 guntas on southern side of my 23 guntas, my lordship.
When
He-
was this? If it
5,
please
2005.
We'll ask Mr. Counsel, let him complete, let the counsel for the respondent complete his
Please.
arguments.
Much
Madam,
Yes.
I sold the property and my lordship, 5/5/2003, my lordship.
Huh?
5/5/2003.
You sold the property?
Yes, my lordship.
Uh,
On southern side of my property, my lordship.
uh.
So remaining what in 21 quarters, I am in possession of the property. I have grown coconut trees, plantation, my lordship. No, in the possession. One disputing only 21 guntas.
How many guntas is 1 acre?
40 guntas.
40 guntas is 1 acre.
Yes, my lordship.
So this is now you have, that is almost more than a half acre is the
Half acre.
land.
Yes.
Entire land is more than half acre.
Yes, my lordship.
Uh.
Yes, my lordship. I mean in possession of
In that
property.
half acre, you sold the property. Then was it while giving that land to him, was it surveyed?
No, my lordship. So my lordship in agricultural land, my lordship, so the one they have can
Now, in this set of disputed questions, how can the court grant injunction to you?
my lordship, the property, my lord, acquired the property under partition deed, my lordship, on 10/3/1997, my lordship.
Here,
So I
nobody is.
produced the document.
no-
Kindly see the page number, my
nobody-
lordship.
No, Mr. Counsel,
29, my lord.
nobody is denying your right or title to the property.
Yes, my lordship.
That's not at all the issue.
Yes, ma'am.
Assuming that it is like, accept the fact that you are the owner of the property. They are also not denying the fact.
Yes,
No,
ma'am.
this 21 and 2 is the only dispute.
Madam, my lordship.
Just like that, if the court grants injunction without you prima facie showing,
No,
where is this 21, where is this?
I am not claiming 23 guntas, my lord. I am claiming only 21 guntas only.
Their case is that 21 guntas, you are including his 2 guntas, is their problem.
No, my lordship. He is claiming is my lordship. His property situated after the 2 guntas, my lordship. What I sold the property to someone. So after on the north side of the 2 guntas, his property situated. He's claiming.
All the more reason that you were the owner of the entire 23 guntas and
Yes.
2 is sold to them.
Yes.
No, that is the only dispute you are raising now.
No, I am not raising my lordship. I am not raising.
You say they are interfering with your 21 guntas.
Yes, ma'am.
Uh-huh.
Yes.
They say with the 2 guntas, you are doing something with their 2 guntas.
No, I am
No,
not.
in
I am not
these
doing
dispute-
something, my
No,
lordship.
in that, how can the court say that you have a prima facie case?
Kindly, my lordship, page number 29, my lordship. Annexure E, my lordship. Impugned auto, my lordship.
Yes.
So, para number 11, my lordship, points 2 and 3, and then next para, my lordship. The plaintiff to substantiate his claim, my lordship, substantiate claim, he has produced RTC extract, mutation register extract, Akar Ban, Uttar, and Yankono certificate. Revenue
No,
sketch.
you have filed everything.
One
Nothing
minute,
is disputed.
revenue sketch is also produced in the trial
No.
court, my lordship.
No, you have filed everything. He has filed his whatever that sale deed that you have produced and whatever it is, that is also admitted by you. That's what I'm saying. No, there is no dispute with regard to your ownership. Now, whether the 21 guntas, whether the property which you have sold is included in this
No.
or not?
No, my
How can the court come to a finding by granting interim injunction?
Madam, my lord, on the south side, my lordship, in the schedule of the plaintiff, my lordship, on southern side, my lordship. So 2 guntas which sold to one Ramesh, my lordship. So I sold to Ramesh, my lordship. That has been mentioned in the schedule of the plaintiff, my
It
lordship.
abuts your 21.
Yes, madam.
It
21
abuts
is.
your 21. 2 guntas is abutting your 21.
No. Our total 23 guntas, my lordship, 2 guntas I have sold. So only.
That's what 2 guntas you have sold. It is part and parcel of 23 guntas. It is one bit of land, is it not?
No, after 2 guntas, madam, so the 21 guntas is,
That
I
is
given
where-
boundaries,
that
my
is
lordship,
where
only
the
21
whole
guntas, madam.
dispute lies. That
I-
is where the whole dispute lies. That 2 guntas, where is the 2 guntas?
My lordship,
That's part of 23. No.
it's not part of a suit, my lordship.
You are missing one
2
point.
guntas is not part of suit, my lordship.
Part of the not the school scheduled property. I am saying 23 guntas is you are the owner of 23 guntas. You sold 2 guntas. 21 guntas you are holding.
Question, yes,
But earlier, before you sold it to the other party,
yes, ma'am.
the entire 23 guntas forms part and parcel of one bit.
Yes, ma'am, definitely. ma'am.
Now the whole dispute is that 2 guntas, according to you, they are interfering with your 21 guntas. And you filed the suit for injunction.
Perhaps the purchase is not interfering my property, my lordship. So defense is the.
Who is he? Who is the defendant?
He is a far relative, my lordship. The
So let us say that purchaser
only
according that the
boundary
two-
disputing the sale deed of 2 guntas, my lordship. He is disputing, so on southern side, northern
But
side of.
please show that he is disputing 2 acres.
lordship.
Please show it from the pleadings.
Kindly see, madam. Is the return statement, my lordship. Kindly, pair number 9, my lordship, page number 15, my lordship. Annexure B. The plaintiff is alleging that he has come in possession of suitable property as per MRO so measured 23 guntas. Out of the alleged 23 guntas of property is an area measured 2 guntas has been sold to one Chikke Gowda, son of Devegowda, as per the registered sale deed dated 5/2003, which has been executed by the plaintiff and his son. The property which has been sold to said Devegowda is shown to be bounded by the property of Sushilamma, son of Ajay Sushilamma is claiming that is the mother of the number 1.
So he is also referring to only those 2 guntas, which you have sold.
So after my lordship, so what is I sold property 2 guntas to my lordship. After 2 guntas, his property situated. His claim according to him.
That fact is very much clear to the court,
Yes, my
which
lordship.
you are getting confused in between.
No.
I am not saying that it is part and parcel of the suit schedule property.
Yes,
It is
ma'am.
not.
Yes, madam.
Suit schedule property is only 21 guntas,
Yes, madam.
but 2 guntas which you sold not to this defendant,
He is
to somebody
claiming
else.
is
He's
situated.
claiming to be in possession of the 2 guntas.
My lordship is claiming is my lordship. So that property 2 guntas is situated between property between plaintiff and defendants. This is the middle of the property, my lordship. 2 guntas. So after 2 guntas is property according to my lordship.
Where did he say so? Please.
That is the main, my lordship.
Again read it.
So sale deed dated 2003, which has been executed by the plaintiff and his son. The property which has been sold to one said Javegoda is shown to be bounded by the property of Sushilamma.
Sushilamma is my mother, my lord.
Yes, my lord. So, my lord, total 23 guntas, my lord, definitely my lord, and southern side of his property is situated. So after selling 2 guntas, so his property so attached to his property I sold to someone, my lordship. So what is 2 guntas is between me and different, my lordship.
Yes.
Is claim. So only is contention, my lordship. So whatever the boundaries is a tribal issue, my lordship. So what is the ingredients for granting temporary injunction, my
In
lordship?
suit for bare injunction.
Yes, ma'am. So
At this point, if
Yes,
such an order is passed, what would happen?
no, my lordship. So my lordship is a different plaintiff is very clear. I gone to.
Will pass an order of status quo.
No, my lordship. Status quo,
let the court
agriculture.
below-
My
No,
lordship.
Suit is of which year?
No. Sort of 5, my lordship.
2015, and now we
15.
are in 2024. How long this
One minute,
injunction
my
go on?
lordship. Status quo is granted, my lordship. This is agricultural land, my lordship.
Huh?
Agricultural land. So I ground plantation, my
Status
lordship.
quo with regard to whoever is in position will be in position.
But should not interfere by 21 guntas, my lordship. That is the main issue.
That is your final relief.
No. Temporary release also is my lordship. What is suppose test is granted, my lords. So my rights will be curtailed, my lordship. He is not able to go to my property, my lords. One day is not allowing me to pluck the coconut, my lordship.
What is that you sought? Please tell the court that come to the plaint, come to the IA, filed in support of the petition.
Yeah, my lordship, see, my lord. This is in Kannada, my lord. In para number 4, my lordship, I mentioned my lordship. So he's not able. I grown the coconut plantation. So he's not able. The defendant restrained me to for plucking the coconut. I mentioned in the para number 4, my lordship. Number is not mentioned. but in scheduled property, I have gone.
No, there is a stay from this court
Yes, my lord. Yes, my lord.
from 2015.
Yes, my lord.
Which year is this? 2021.
2021, my lord.
When was injunction granted to you?
2016, my lord. August 2016. 10/8/2016. Annexary, my lord. Annexary. Page number
I
21.
know what has happened thereafter. This, you
My
filed
lordship, my lordship, till stay granted by this corporate, I am enjoying my property. So stay has been granted by this court, so I'm not able to, cultivate our land also, my lordship. And
No,
even during the pendency of this
No,
petition,
no,
my
no.
lordship.
Any from the last 3 years, there's a stay by this court. No, at this stage, we'll direct the court below to dispose of the suit itself within 6 months.
But should not be in the, no, my
What is
lordship.
happening-
So,
What is happening from the
my
last
lordship,
3 years?
my lordship is not sort of the different my lordship. Sort of plaintiff, my lordship. So my lordship, whether he has grievances against the plaintiff, he can work out the remedy by filing a separate suit, my lordship.
No, my lord, rightly my friend said that there is a dispute. with regard to
Only, my lordship, and even though my lordship is not a part and parcel of the surrender number 241, my
No,
lordship.
this
Kindly see the my lordship.
Now this writ petition is not heard now, and it is heard after some time. Now the interim order would continue.
My lordship, I was every day, my lordship, in,
No, we will ask the court
no,
below to
every day,
dispose
my
of the
lordship
writ
is not
petition in
facing
6
very
months.
ideal time, my
At this
lordship.
stage, in the
My lordship,
particular
trial
facts
court
of-
and first appellate court is granted interim order. No, I am not saying my lordship. So my lordship is very difficult, my lordship, to cultivate the land, my lordship. My property is 21 quintas only, my lordship. But my rights should not be curtailed, my lordship. That is in respect of number, measure 21 quintas, my lordship.
agreed with the order. Passed with the.
Another one on my submission, my lordship. When even temporary injunction granted, madam, I'm not able to get benefit of the interim order, my lordship. So then only I can I have filed application for protect to direct the judicial police to assist the plaintiff, my lordship.
That is ordered, you have taken it.
Taken earlier, my lordship.
MA number, agreed with the orders passed in MA number 20 of 2016 by the senior civil judge and JMFC Krishnaraj Pet. Confirming the order passed by the trial court in
Madam, my lordship, one moment. So another property is my lordship.
in IA number, 1 minute, IA
For
number
complaint has been
1,
largely changed.
dated 10th August 2016. The defendant is before this court. Yes, what is it?
So one more complaint has been filed against him, my lordship. So he damaged my property, my lordship, another property. Not only this property, my lordship. So he is intentionally is doing some.
We'll ask the court below to put an end to this litigation. That's the only thing that can be done under these circumstances.
No, my lord, don't, at least my lord, 21, at least my lord, I am not interfering in situation, my lordship.
What do you want the court to pass on? What kind of an order you want now?
No, my lordship, my rights, in respect of 21 gundas, my lord. That can be.
That's a whole disputed one. Why you not
21 gundas is not
understand?
disputed, my lordship. Only disputed 2 gundas.
Right.
Where is the 2 gundas is a question now.
No, 2 gundas also is not questioning. Is after 2 gundas, his property situated. That is his case, my lordship.
That I'll record. What did you write? This court, the plaintiff herein had filed a suit for injunction in respect of an extent of 21 guntas of land. It is the case of the defendant, it is a case of the plaintiff that the property is an ancestral property and which has been in his possession and enjoyment from a long time, and he has grown coconut plantation in the said property. The defendants are trespassing into the sue schedule property and trying to grab the yield and troubling the plaintiff. And in this regard, a panchayat was held It is also admitted by the plaintiff that out of 23 guntas of land, an extent of 2 guntas of land was sold sold by virtue of a registered sale deed on 5/5/2023. 23. In support of his case, the plaintiff had produced the RTC extracts, mutation register extract, Akkar bond, UTAR and encumbrance certificate, a revenue sketch, which shows that he is in possession and enjoyment of the property. In survey number 241/1. And the Panchayat Pallu Patti dated 10/3/1997, the khata of suit property mutated in the name of the plaintiff. And the said RTC column number 10, it is stated mode of acquisition of property is as per MR number 85 of 2001, as per partition, and in column number 9 and 12(2) of the said RTC, the plaintiff has entered as in possession, cultivation, and enjoyment of the suit schedule and record of rights document. The next paragraph. The defendant has filed his written statement and has denied the possession of the plaintiff, and they have disputed the boundaries and extents of the suit property. It is a case of the defendant that out of 23 guntas of land, 2 guntas has been sold to one Chikkagowda as per the registered sale deed dated 5/5/2003. Where is your where is the written statement filed?
By the annexed B, my lord.
Annexure?
B, my lord, B, my lord. Page number 14, my lord. Start of 14. Para 9 and 10 are relevant, my lord. 9, 10 and 14, my lord.
The property which has been sold to the said Devagowda is shown to be bounded by the property of Sushilamma. The said Sushilamma is none other than the mother of the first defendant herein and mother-in-law of the second defendant. The said property which is shown to be in possession of the said Sushilamma is in actual possession of the second defendant. The second defendant has built a house which has also been assessed by the village panchayat. Before undertaking construction of the house, he has even got prepared a sketch by the surveyor. He mortgaged the said property to take financial assistance from the government. The plaintiff, with an intention to grab the property of the defendants, has come up with a false and untenable story. And the plaintiff is not at all in possession of the property that has been detailed in the plaintiff. The defendants are in possession of the property which is lying towards the north of the property sold by the plaintiff as per the sale deed dated 5/5/2003. The the trial court has observed that on perusal of the material, it appears that the case involves serious questions of law and facts and requires trial. Whether the plaintiff is in possession and enjoyment of the suit scheduled property as on the date of the suit, or whether the defendants are interfering with the plaintiff possession, peaceful possession and enjoyment of the suit property, question mark, or but the plaintiff is entitled to the relief sought in the suit and all other things or factual aspect okay, which can come to light only after a full-fledged trial. And the court observes that as this case involves serious questions of facts and law, which are tried by the court. Hence, the plaintiff has made out a prima facie case for trial. Then when it comes to the balance of convenience, the court considers the documents that are filed by the plaintiff and the defendant and observes that at this stage, defendants have not produced any documents to show that the boundaries furnished to the suit property is not correct and measurement is not correct. Hence, the court comes to the conclusion that the property is in possession of the defendant. And if an interim order is not passed, it would cause the balance of convenience in his favor, and accordingly had allowed the application filed under Order 39, Rule 1 and 2 CPC. The same was carried in appeal, that is MA number 20 of 2016. And the appellate court, by order dated 16th March 2021, has confirmed the order passed by the trial court. And also observes that whether the plaintiff establishes the boundaries of the suit schedule property or not is a tribal issue. And as the revenue records establish the position of the plaintiff over the suit schedule property, basing on the material placed before the court below, it has come to a right conclusion that there is a prima facie case in favor of the plaintiff and confirm the order. Agreed thereby, the defendant is before this court. This court heard the learned counsel for the petitioner as well as the learned counsel for petitioner, defendant and the respondent plaintiff. The learned counsel for the defendant submits that, petitioner defendant submits that the court has failed to take into consideration the particular aspect of the mentioning the wrong boundaries. And by virtue of this order, the petitioner, the defendant is put to irreparable loss and hardship. When the court itself observes that there are disputed, the facts or there are several disputed questions of fact and law involved in it. And without there being a prima facie case being shown by the plaintiff, ought not to have granted the injunction. And the appellate court has confirmed the order of the trial court. Next part. Learned counsel appearing for the plaintiff submits that, in fact, the defendant, the plaintiff is carrying out the agriculture activities and the defendant day in and day out is interfering with his possession and enjoyment of the property. It is submitted that there is no, even the defendant is not denying the fact that the 21 kuntas extent of land belongs to the plaintiff. And the other disputes, as rightly held by the court below, can be decided during the course of trial. And as he could satisfy the three ingredients, the court had rightly granted the injunction, which is confirmed with the appellate court. And after the orders passed by this court, which date? It's like a book, the interim orders book. That by order dated 25/8/2021, no, it is much clearer to that.
30th of March 2021.
30th
of March 2021.
30th of March 2021. 30th of March 2021, and which was extended thereafter. In fact, the petitioner And then the petitioner defendant is continuously harassing and he had to file an application. And in fact, he has also filed an application seeking police protection. And hence, unless the stay is vacated, it
My
will
lord,
cause
my lord,
lot of
this application was filed during the pendency of miscellaneous appeal, my lord.
unless the stay is vacated, the plaintiff would be put to irreparable loss and hardship. Anything else?
No.
Having heard the learned counsels on either side, there is a material on record. The undisputed facts are the plaintiff is the owner of, is the owner and possessor of 21 guntas of land. It is also an admitted fact he had sold an extent of 2 guntas out of 23 guntas which earlier belonged to him by way of a registered sale deed dated 5/5/2003. As per the said sale deed, the property is abutting the property of one Sushilamma. The Sushilamma is none other than the mother of the defendants. The mother of defendant, defendant number one, and mother-in-law of defendant number two.
Yes, ma'am.
The mother-in-law of defendant number two. Now, the whole issue and the dispute between the parties is with regard to the respective ownerships are not in dispute. But who is interfering with whose possession is a dispute that has to be decided by the court. Now, both of them have their own respective documents with regard to their possession. In a case of this nature, the court cannot say that by filing certain documents, the defendant has, the plaintiff has established a prima facie title. Because there are, the trial court observes that there are disputed questions of fact and law. And at this stage, the plaintiff has made out a prima facie case. That finding of the court cannot be sustained. The court, while granting an injunction in a particular, these kind of disputed facts, the court ought to have been more careful, which will unnecessarily give rise to the litigation between the parties. Right from 2021, there is a stay on the order passed in the IA granting injunction. This is a suit of the year 2050. At this stage, this court is not inclined to vacate the stay granted by this court. And in the facts and circumstances, this court deems it appropriate to direct the trial court to dispose of the pending suit as expeditiously as possible, but not later than 6 months. Accordingly, the writ petition is disposed of.
Okay.
The order of the appellate court, my lord, annexure F, my lord.
What is that?
Annexure F, my lord, it should be kept in abeyance for some time. Annexure F, import order has to be set aside, my lord.
But maintaining the stay granted by this court, let the stay be continued till the disposal of the suit.
My lordship, no, one minute, undertake my lordship. He's claiming only house property, my lordship, not the 21.
No, let the court decide.
Please wait.
He should not interfere my 21 guntas, man. I will also interfere what he constructed my house, my lordship. This is the case, my lordship. That can.
No. My lord,
That's what you were submitting before. Now you can't change it. You said so, that you have a house constructed and is interfering. The children are staying in that. So if you have a house in that, let him not interfere with your house. Not till the main suit shall be decided. And now the dispute, it is contended with the learned counsel for the defendant that he constructed a house and he is residing in the same. The defendant, the plaintiff shall not interfere shall not interfere with the house with the possession and enjoyment of the defendant with regard to the house. And the defendant shall not interfere with the agriculture operations of the plaintiff.
Inland around my house, my lord, I have grown some coconut trees and arrogant saplings. House is a small house, my lord, inland around within the 2 guntas.
House and around whatever around and in the entire 2 guntas, he can't construct a house.
No, that's what I'm telling, ma'am.
And
no, he's claiming only 2 house property only, madam. He's not.
let it be there.
Please. Problem.
My lord, inland around my house, my lord, please, my lord.
Yes.
Inland around whatever that I have grown, whatever is in my possession, my lord.
My lord.
My lord.
No adjournments, no.
Serial number 20.
Petition is died, my lordship.
Which one?
Serial number 47, my lordship.
It is submitted that.
It is
47.
already recorded, my lordship. Kindly dispose.
Huh?
Kindly dispose. Dismiss, my lord.
It is dismissed as abated. 47, land council petitioner submits that the petitioner died, dismissed as abated.
But
My
serial
lord,
number
serial
22 was adjourned at the request of the respondent in the morning, my lord. There's an interim order. It's not informed of.
Which one?
Serial number 22.
22.
20.
Interim order earlier granted is extended. Please look at it. If it is there, extended to the next day.
My lord, serial number 50, my lord.
No adjournments now.
Orders alliದೆ.
Huh?
Orders
Huh.
kind of next week, my lord.
Why?
Not council, my lord, not keeping well.
No, you should have made a request in the morning. No, that the court entire day can't take up the all these requests. Which matter is that?
50, my lord, serial number 50.
And please from tomorrow, never make a request in the afternoon. 50 at the request of land council. It is submitted that the land council, the petition is not keeping well. Most after 2 weeks, give a date.
Give a date. Give a date. 2 weeks. ಅದು FC ತಗೊಳಪ್ಪ 15/7. Petitioner died ಅಲ್ವಾ? Submit that petitioner died.
Petitioner ಸತ್ತೋಗಿದ್ದಾರೆ. Impeding application.
ನೀವೇನ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದಿರೋ ಡಿಸ್ಮಿಸ್ಡ್ ಆಸ್ ಅಬೇಟೆಡ್ ಪೆಟಿಷನರ್ ಡೈಡ್ ಅಷ್ಟೇ. ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 25 ಡಿಸ್ಮಿಸ್ಡ್ ಆಸ್ ಇನ್ಫೆಕ್ಷಿಯಸ್. ಬೆಳಗ್ಗೆನೆ ತಗೊಂಡೋಗಿದ್ದಾರಲ್ಲ. ಮೈನ್ ಮ್ಯಾಟರ್ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆಯಂತಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಏನ್ಸ್ ದಟ್ ಈ ಸಬ್ಮಿಟೆಡ್ ದಟ್ ಇಟ್ ಹ್ಯಾಸ್ ಬಿಕಮ್ಸ್ ಇನ್ಫೆಕ್ಷಿಯಸ್. ಪೆಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿದ್ದಾರೆ.
ಮೇಡಮ್ 50 ತೆಗ್ದಿದ್ದೀನಿ.
ಎಲ್ಲೋ
ತೆಗ್ದೇ ಇಲ್ಲ ಆಗ್ತೆ.
So 2:30 ಬರ್ತಾರೆ ಮೇಡಮ್. 2:30 ಮಾ.
ಅದು ಎಂಟ್ರಿ ಮಾಡೋಣ ಅಂತ ಹೇಳ್ಬಿಡಿ ಮೇಡಮ್. ಮೇಘನ್ಗೆ 22. ಇದು ಆಫ್ ಮಾಡ್ಬೇಕಾ? ಏನ್ ಮಾಡೋದು? ಮೇಡಮ್ ಇದ್ರದ್ದು ಮೆಮೊ ಇದ್ರಲ್ಲಿ ಆಗ್ಬಿಟ್ಟಿದೆ ನೋಡಿ. 29,115 ಫೈಲ್ ಇದೆಯಂತೆ.
ಏನ್ ಮೆಮೋ ಅದು?
ಅದೇ 29 ಅಲ್ಲಿ ಮೆಮೊ.
serial number 29
ಅಲ್ಲ 29 ಅಲ್ಲ 19.
19 ಇಲ್ಲೇ ಇದೆ.
ಇಲ್ಲೇ ಇದೆ ಅಲ್ವಾ?
part
ಮೇಡಮ್
ಎರಡು.
ಅದ್ರಲ್ಲಿ ಇಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅದು ಅಲ್ಲಿ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಇಲ್ಲೇ ಇದೆ ಅನ್ನೋದು 19. ಅದೇ 19 ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಈಗ ಕೊಟ್ರಲ್ಲ 50 ಅದ ಅದೊಂದು ಫೈಲು ಚೇಂಜ್ ಆಗ್ಬೇಕು. ಇಂಟ್ರಿಮ್ ಮಾಡಿ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳಿದ್ದಾರೆ. ಅವಳು ಬಂದ್ಬಿಟ್ಟು ಇಟ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ಟಿದ್ರು, ಸೈನ್ ಆಗ್ಬಿಟ್ಟೈತಿ. ಅದನ್ನು ವಾಪಸ್ ಕೊಟ್ಟು ಮೇಘಾ ಶೆಟ್ಟಿ
ಯಾರು ಮೇಡಮ್?
ಮೇಘಾಗೆ ಕೊಟ್ಟು